that's minimal, but I do want to make it as easy as possible to follow our coverage here. So that's kind of my thought process behind why I'm not putting the stream to make it as easy as possible to follow our coverage here. So just to try to keep it easier. But that is my intention, to come through and recap tonight and tomorrow as well. Willow's Angel, anyone greeting to you from California. You are doing an amazing job. Thank you. Thank you so much, Willow's Angel. I am looking forward to coming back down to California in the coming weeks to collect myself a nice pile of trial exhibits, which the court properly recognized. Yeah, I have a First Amendment right to have, to see and to share and to publish and to talk about what they show and how they relate to the choices of the parties to make use of this public resource for dispute resolution that we provide in our court system. That one's a civil case, family case. Yeah, the First Amendment isn't just about monitoring what the courts are doing. It's about what the parties are doing too. Are they making good use of this public resource that we fund and provide? Another thing we get to talk about. Do we need to maybe do things to make it a little harder to abuse the system? What might that look like? We might be having some of those conversations in the coming days. Willow's Angels, I think you did this twice. Thank you so much for your greeting. I appreciate it very much. I appreciate your support. Appreciate you being here. User with numbers. Rideau issues can be dealt with in jury selection. This has been the constant theme throughout all of this this jurisprudence, is that jury selection is where you deal with these things. That is the mechanism that we have in place. So that's why we don't gag the press, why we don't have prior restraints. That's why we don't have per se rules that you can't have cameras in courtrooms. No per se rules about, you know, being able to display exhibits in open court. And Chandler's made the point that has been then carried out in the First Amendment case law that's developed, the First Amendment right of access case law that's developed, that boy, now I forgot what I was going to say. You deal with these problems in jury selection. Yeah, sorry guys, forgot where I was going with that one. I had a thing and then like instantly lost it. It'll come back to me at some point, probably at like 4 in the morning tonight. But yeah, Rideau. Oh, I remember. The recognition is that there's no difference. Publicity is publicity. There's nothing like inherent about cameras that is worse than the fact that the press has, since time immemorial, since the founding of this country, reported on details of what's happening in court. And so if the whole problem is, oh, we get to know things before the trial, that's a problem that the country has accepted since it's been founded. We looked at the Press Enterprise 2 last night, where the court went through the history and tradition of access to preliminary hearings and pointed to Aaron Burr. Aaron Burr, remember him? Treason trial. And talked about his probable cause hearing and how much public interest there was, to such an extent that they had to move it to a new building because the courthouse wasn't big enough for all of the spectators. Because the public was interested in why are we charging Aaron Burr and what's it based on? So it's always been understood we have a right to see those things. We've always talked about them, reported on them. There's no magical transformation that happened with the advent of television and videography and live streaming. It's the same information. It's just kind of better because it's firsthand. It's not being filtered through other individuals. It's not being edited, compiled, and so forth. Yeah, that's Rideau was a jury case. It's really primarily a jury case. And I just couldn't help but notice how the due process problem resides everywhere, but with the police who thought, yeah, let's video a guy's interrogation and then give it to the news media. And like literally within days, you know, within days. Let's blow this guy up in the press. Don't feel like that would fly as an approach in this day and age with, you know, our gag orders and so forth. Trial participants. Unduly noted is a new member. Welcome. Welcome to the channel. Thank you so much for your support. Yep, that's the one we talked about. User numbers, user letter numbers. Press Enterprise. This is Press Enterprise 2. There were 2 Press Enterprise cases. They were major cases in the First Amendment right of access out of the U.S. Supreme Court in the early. Was, but it was early 80s. And Virginia newspaper says, first time there is a First Amendment right of access on the part of the public to attend and observe criminal trials. Period. You can't exclude the public from the courthouse. But then the question becomes how far-reaching is that particular holding? You say criminal trials, okay, but what about pre-trial processes? What about the non-substantive parts of the trial? So the first time this came up, jury selection, that was Press Enterprise 1. And they said, yeah, it's important, critical for us to be able to see that, to know how the people who are going to decide the case are being vetted. That's part of us being assured that this is a fair and just process. Then in Press Enterprise 2, they came back about our access to the preliminary hearing. So the public had been excluded from the preliminary hearing in that case. So then the media wanted the transcript. Court wasn't giving it to them. Went all the way up to the U.S. Supreme Court. U.S. Supreme Court said, yeah, had a lot to say about why it is just as important for the public to be able to view the preliminary hearing as it is to be able to see the trial. And once again, of course, it's reasonable to be concerned about the effect of the public kind of pre-seeing the evidence, but the remedy for that is in jury selection. Press Enterprise 2 is a very strong case for this purpose. Got the sound on, but just not speaking yet.
Good morning. Thank you for the party's patience. Court is now in session. Calling case number 251403576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Is it me or are things a little quieter today?
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard. For the state, County Attorney Jeff Gray also present.
Good morning.
Let me see if I can boost the volume for us a little bit.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser here for Mr. Robinson, who's seated at council table.
Good morning.
Good morning.
Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of Miss Erica Kirk. Good morning, Miss Kirk. All right, as you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. And this prohibition does not apply to legal counsel and support staff or the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions. So I am turning off my ringer.
Mine's still off.
I invite you to do the same.
It was on yesterday. Don't know if you
Every
guys
person who is in attendance today and every day will be afforded the dignity and respect due to them, and pursuant to the standing decorum order by the court, all spectators shall be quiet.
He does.
Civil
seem tired,
and orderly.
doesn't he?
Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing.
Crazy people, right?
Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or to the status of this case as a capital offense.
Yeah, I agree. There's something with the vibe today.
As we begin this morning, I wish to. I've taken a lot of time to think about the comments made by the parties yesterday, and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me. And I took the time this morning to review what was filed since we adjourned yesterday until we've came back on record. One of the motions filed last night was filed by Ms. Erica Kirk's attorney, and I wish to address that. And I realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed by the attorney for victim representative Erica Kirk to the state.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and indeed honors the victim representative's right to be present in at this hearing.
Thank you, Mr. Ballard. To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading. I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution. I think that the rulings that the court has made the last few days do so. And I don't believe that the issues that are presently before the court going forward with the hearing with respect to exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday. But we have witnesses we have to get to, including a defense witness who is not available after tonight. So
why wouldn't you want to spend time on the law, Mr.
I could,
Novak?
of course, as Your Honor knows, say much more. But the court has all the briefing, and I think we should move forward.
Thank you. And as it relates to transparency and publication, does the news media wish to be heard on this issue?
Only briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this three-step process. And I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are three separate inquiries. Of course, the media believes the media will be the party who stands here at this lectern and says, we believe we should see as much as possible. We're maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on the live stream cannot, is a meaningful victory for transparency. And we, of course, support that.
Thank you. All right.
I don't like that.
The state would like to be heard on the briefing briefly.
For
The briefing that was submitted last night.
all right, so I want to address the motion filed by the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it all addressed. So in regards to that, and I appreciate the position of the parties, it is important for me to hear all sides. Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness, respect, and dignity, and the right to be present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims' representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed only to the gallery. And third, if it will be published through the camera to the public at large. This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Ms. Robinson's constitutional rights. Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to go.
We do want to be heard on the briefing from last night and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit to that. Is that correct? I do.
And there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record, okay, and then I'll hear from you. I just want to make sure you're able to be afforded everything. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played. And then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties?
Yes.
All right. The state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
Judge, I think, Your Honor, and then let's just see what the court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed, ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue. I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does. Plus the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right. And this is what I'm going to next. Mr. Ballard.
Yes, Your Honor. I think we're on the same Same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here in this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page based on what the court just said.
Did you say 5 more minutes, 2029 to 2020, 25, 23?
Your Honor, I think we have just a 1 second difference. Our timestamp is 25:22 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second, we are all in agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it,
right,
you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well.
Oh, Lord.
And this is very short, and so I'll leave it to the state if you wish to just in real time pause and fast forward or wish to redact it. I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes, 18 seconds to 27 minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
7. Another 14 seconds of audio we won't get to hear.
Your Honor, just to make sure that we've got that correct, the additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Yes.
And Your Honor, while we're talking about additional redactions, let me approach.
Not going the way I hoped.
When Your Honor made his ruling yesterday afternoon, it wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence. And I would like to be able to point the court to those. We've got 2 brief portions that we believe don't implicate those concerns and should not be redacted.
All right.
Does Your Honor have the transcript?
I do.
In front of you? Okay.
This transcript should be in the court record as well at this point too, because he's relying on it. Part of his adjudicative materials. So I hope somebody preserves that.
First of all, at the very, very bottom of page 10, beginning with the words, was he? And then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see was he at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see. Right here. Okay. Now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from was he on page 10 until
16, the timestamp 1646 on page 11.
Okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19. And it begins, let's see. It would be the fifth paragraph down, Mr. McBride stating, okay. And then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
Thank you. Yes, you may.
Of course, he wants to be heard.
Thank you, Your Honor. With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that was not a section that we asked the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted, redacted transcript,
See that?
and the court agreed with us. This is not relevant. This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twiggs, and now I'm going to quote the Utah Rule of Evidence, has any tendency and reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon, but from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript, which we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue prejudice.
All right.
I am not Mr. Twiggs' representative, but I think as a witness who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be. But my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything of significance, especially in compared to undue prejudice.
You're not his advocate, but you're
you.
going to speak
Thank
like you
Mr.
are.
Novak.
Put
Mr. Ballard.
words in their mouth.
Thank you, Your Honors. Mr. Novak recognized Mr. Twiggs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him. And then also it's very relevant to the enhancement that we have charged.
All right.
Targeting. Yep.
Thank you. Anything further before the court rules on these two requests? All right. In reviewing the first section, again, citing to page 10, and I know it is, to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 1539 on the video, starting with was he, and ending at 1646 with the last word asking. After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327, going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct. Yeah. Yes. Right after 3255, where Mr. McBride states, okay.
I see. Thank you. Let me just take a quick second to review this. In relation to that request from right after 3255, starting with okay, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with okay, ending at 3327 is, the court finds that their interest is served by not publishing this to the courtroom or to be broadcast. I note and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds independently that this this portion shall not be transmitted into the courtroom.
That's not a finding. What's your finding?
Of certain statements made in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at OK, until just before 3340. I'm sorry, up to 3340 may be published. Did that notation make sense?
To the state, Your Honor.
All right, to defense.
Understood.
And so this is the appropriate balancing of being transparent while at the same time maintaining the constitutional rights or balancing the constitutional rights of all parties and what is appropriate for publication. And this may be published not only to the gallery, but to the media as well that goes beyond the gallery itself. All right. Anything further on State's Exhibit 16?
Not from the state, Your Honor. Thank you.
All right. And I know defense is nodding their head as well and not indicating any more is needed to be discussed at this point. All right. I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Thank you, Your Honor. We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case.
Yes.
And what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence. And Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the statements, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then it was the police that immediately released that recording to the press, who then publicized and televised that, the defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate. Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value, and even if it did, the circumstances are completely different than the from the types of statements that we're dealing with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. Ooh. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. Yep. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And the court, because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to to attend the hearing. That's a hollow promise. If the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No, not this time.
He didn't say Chandler, but he referred to it subsequent.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. It wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom,
oh Lord,
we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kirk's counsel. The state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that the blanket rule that there is unrebuttable prejudice that's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, a Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them makes them unable to serve. But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case that the Supreme Court talked about in Skilling. We wouldn't have any state action giving rise to this problem if we didn't have cameras in the courtroom. And that's why we think that exhibits 16.1, 16.2, and 16.3 need to be managed in the way we've asserted. Thank you, Your Honor.
Thank you. Mr. Ballard.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits unredacted, be published in the courtroom, not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public, and the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is going to rely on.
Us?
And that is even more important to the victim representative's right to be able to be present and to observe these proceedings.
Why not us? Why don't we matter?
Thank you.
Why don't we matter, Mr. Ballard? Media lawyer, get up there. We matter.
All right, Counsel.
We matter. Remind him that we matter. Thank
Your
you,
Honor,
sir.
if I may, I'll be brief. I want to begin by saying thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today and the nimbleness that's required to talk about things like the transcript in open court is a challenge. I recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. I know the public does as well.
Shut up. Move on.
The only thing that I want to say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously in the wake of Rideau. It's obviously in the wake of Estes. It's here in this state, unanimous Utah Supreme Court, upholding a decision made by Judge McCleave below in a case that has striking parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told me that he was involved in the shooting, gave me details of it, threatened me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's a presumptive right of access for the public. The second question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea of sealing a document that contained allegations or details that were already in the public sphere would only create the impression that information was being kept from the public when it was not. We stressed what we did yesterday, that as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognized there's a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that information is already in the public sphere. That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But we that do recognize that middle step is a meaningful one. And if the court were to decide that information be shared in the courtroom, but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Counsel?
Good morning, Your Honor.
Yes,
Jeffrey
we don't
Nyman on
matter to
behalf
media.
of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing. And they have a right to be here, and they have a right to hear the evidence. They have a right to see and feel what's going on in this courtroom, just like, and they want to understand, Judge, what you were viewing. They want to see the evidence. And we understand you have to balance. But at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom, for them to see it. The Utah Constitution gives them the right to be here, and to be here and not to see the evidence, what's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, Counsel. Anything further as it relates to exhibits 16.1, 16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to
Nobody thinks we're important, I
make
guess.
sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
All right. And just to be clear, as it relates to the state's request, 16 point, well, six, so under the three factors or the three levels: admission to the court, publication to the gallery, and then publication beyond the gallery. What is the request for each of these exhibits?
We are asking. Your Honor, we are asking for admission. We are asking for publication within the courtroom, but not publication electronically on to the electronic coverage in the courtroom or of these proceedings. We do want to make clear that once the exhibit is admitted, that the witness will be reading from portions of the exhibit, but then, again, we're not asking that that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
So then how is it cumulative to hear it in the interview if we're not going to see it here and all we're talking about is publication? We are not sitting at home hearing it twice. We are sitting at home hearing it 0 times.
16.1 is the text messages. 16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
All right. And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing, how much of 16.1 has been published to the public prior to these proceedings? And this is open to all if you wish to weigh in. I just want to make sure that that's clear because that wasn't really addressed in the briefing and it's a factor. So I want to make sure that that issue has been presented by the parties if you choose to.
Don't forget about the search warrants because those are also public records. Even if they haven't gotten all of the attention everywhere that the information got.
Your Honor, with respect to Exhibit 16.1, some of those text messages do appear on pages 8 and 9. Pages 8 and 9 of the information that is public.
Could you give me a rough estimate or percentage of how much of the total amount of 16.1 appears not in the information? Again, I'm just trying to create a record of what is out there.
A lot of attention in the mainstream media. Doesn't mean they're not public. If you find them and you want to shoot any of them my way, or even just like the case number or anything like that it's filed under, please do, because I would kind of like to compile these. It's just that it is like a big undertaking to try to, hunt all of them down. But it would be nice to have a kind of central repository of all of this stuff. Instead of like, few people have found this and, talked about it on their stream, like yada, yada, one on Scribd here. And it gets difficult to kind of keep track of everything. Ginger Puff, I would love that. aburkhartlaw@gmail.com. Yes, I said that on the stream. Probably shouldn't have, but I did. Feel free to shoot it to me. Oh, this is the constant problem. Everyone asks. Oh, you're too kind. These guys are good. These guys are good. They're just not advocating for us.
Your Honor,
Taking this middle ground
State's Exhibit
position.
16.1 is 18 pages total of photographs of text messages. It's approximately 5.5 pages of those 18 pages that are reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly. Anything
So not
further
quite 1/3.
from any party?
Nobody's going to mention the search warrant.
To defense?
Media probably doesn't know because
the
none of their
prosecution.
mainstream
No, Your Honor,
people have
thank you.
published it.
Media?
I'll just point out for the court that in addition to the text messages, I believe, I haven't seen the other exhibits, but I believe that at least the note itself, which is another one of the exhibits, is also described in the information.
Thank you. Ms. Kirk's victim representative attorney.
This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened, Charlie. So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered for, again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication. It's in the courtroom and beyond the courtroom. And so this is the ruling as it relates to the briefing. And I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on state's request to publish exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment. The defendant relies on Rizzo versus Louisiana Estes and Skilling, and ask the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rideau and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rideau because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing. The defendant's due process interests, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rideau, Estes, and Skilling. Unlike the broadcast interrogation in Rideau, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial. This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on exhibit 16.1, because it contains information including a phone number and address to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court.
Thank you, Judge. What about the
Counsel,
others?
how
We'd
would
like
you
the
like to
others to be
proceed?
broadcast too. But those are just in court. The Discord.
Your Honor, just to
and
clarify the record, the state has redacted that portion. We anticipated that needed to be redacted in 16.1. So we have redacted that portion. We believe that the best way to proceed now is we have the edited video ready that comports with the additional edits that the court has ordered. We propose that we take a break so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming back and playing Exhibit 16.
All right. Okay. All right. I appreciate the caution being exercised by all parties. We'll take a 15-minute break, come back at 10:50. Court is in a brief recess.
Oh, Judge Graff, once again. See, yes, I still have faith in the judge. He has consistently given us more than the parties have asked for. Literally everybody today, even the media lawyer, was like, fuck those people at home. Forget about the cameras. We're not even worried about the cameras. You don't have to put it on camera, Judge. And he's like, yeah, at least the texts, you can put them on camera. They're already out there. Didn't say they can publish the note or the Discord chats. So I don't love that. Again, it goes back to this question. If we're not going to be able to see them discuss it on the video because it's cumulative of what's being admitted, but we're not going to be able to see what's being admitted, then it's not a cumulative problem. A cumulative problem is you're getting to see it twice and that's unnecessary. Our problem here is we're not getting to see it at all. So the state has told us, even if they're not going to, publish these other exhibits, 16.2 and 16.3, the Discord chats and the notes, even if they're not going to publish those or have them televised, they're still going to have the witness read parts of them. I hope they're thorough with that. Hope they're thorough with what they allow to be brought into the public record. Again, it's like the justifications are so like all over the place and shifting that hard to find the consistency, right? The concern has been, oh, we can't put it on camera because I've already said you're not going to be allowed to copy them. Why not is not entirely clear, but no, media is not going to be allowed to copy the exhibits. And so putting them on TV would just enable the media to screenshot them and then have the copy that the court has said we can't have for reasons that are not entirely clear. But somebody reading it under this reasoning should be fine. Should be fine. We can't screenshot that. Does there seem to be a little bit of a form over substance issue going on here with this morass that we're in? It's the same information. It's just got to be delivered to us verbally in words instead of visually in writing. This seems just really not intuitive, not common sense. Why would this matter? Why would this distinction matter? Why does it matter? I don't know that that's really been articulated. Why is it okay to hear it but not to see it? Okay, it can be copied and then published and proliferated. This hearing can be clipped and published and proliferated. It just boggles the mind a little bit. As far as the note's concerned, again, we already know what the note says. I mean, under his reasoning, if the texts, we're getting to hear them and have them published because they're already public, the note's already public. The contents of the notes are already public. And so I'm not even really that concerned about the contents of the note. I sure would like to see the photograph, though. I'd like to see the condition of the paper. Go ahead and redact the words. We already know what it says. We've been told. But I really would like to see the condition of the paper. We're all kind of curious about that. Who did that? Who did that? Is that why Lance needed immunity? Was that Tyler doing it? Consciousness of guilt? We'd all like to know. I think that seems kind of important to understanding what happened here. What's at stake? Who participated? How? And the significance of this evidence. The evidence has very different meaning if it was a note left by Tyler for Lance, as is reported in the text, and Lance himself voluntarily, of his own accord, destroyed it. Then if it's a note from Tyler, and Tyler himself destroyed it so that it wouldn't be discovered. That one's consciousness of guilt. Lance acting independently is not. So this is kind of an important issue vis-a-vis guilt and the evidentiary value of this particular piece of evidence. I said, and I knew the court's not going to adopt a maximalist position. They rarely do, you know, find the middle ground. But I just hope they see the problems that it's creating and the inconsistency, the problems with the reasoning. Because I certainly see it. You don't get to call it cumulative when you're not showing us anything. Ay. Well, we're going to have to see how this plays out, I guess. But I do appreciate the judge giving us more than anybody asked for. They were all ready to just cave it. Fuck those people at home. To show it in the courtroom. And the judge is like, nah, I'm going to go ahead and let the cameras capture all of this. So we won't hear them reading it on the interview with Lance because it's cumulative, but we will get to see it published in court. So we've seen a third of it in the information. There's more of it that, came out in the search warrant affidavits. Can't really, say how much, how much more, what percentage more. I don't know because we don't have the whole thing. But seems like now we're going to get to know that. We'll get the whole thing. So, I still do have faith in Judge Graff, but I know he's got to be attuned to the difficulty that he's in. And that the logical inconsistency here is a tell. It's a tell that the logic itself is not driving the train here with these decisions. It is being used as a justification for what they want to do and what they think is the right way to handle it, which I also do appreciate. I appreciate the judge wants to do this right. But what's right is, or should be, driven by the law. And so it's a tell that, we're being a little inconsistent with our reasoning here because it's not driving your decision. It's your justification for getting to where you want to be. But you're having a hard time finding legal support for it. That's why you're tripping over your own feet a little bit. Kyle Cowden, it hit me, finally, who the judge reminds me of. Michael Strong as Dr. Corbin in Star Trek's What Are Little Girls Made Of? I don't know who that is. Let me Google him real quick. Michael Strong as Dr. Corbin. Oh, yeah. I see it. It's vaguely there, but the same, silver. I get it. Jeff would have known that reference, but not me. Not me. Lax Forge, why did the judge suppress Mitchell 1102 statement on religion and politics? We got two different things going on here. The Mitchell statement was not on religion and politics. The Englehart statement, gentleman from Turning Point USA, he provided 1102 that includes this information on religion and politics. So two separate things going on. Mitchell, the state simply didn't offer to publish it. And so the court didn't force them to. It was the state who decided we, the public, shouldn't see what Mr. Mitchell, who was the family friend who assisted with Tyler Robinson's surrender. We shouldn't see what he has to say at this point. The court should, but not us. And so the judge went along with that. With Mr. Englehart's statement, let me go back to, he did find, I think that one again, it was similar. He found that it was going to be relevant for his purposes, for purposes of admission, because it goes to motive and it goes to the victim targeting enhancement. But I think, again, it wasn't published. Let me go back and try to find in my notes where that was dealt with. Let's see here. Okay, found it in my notes. Here's the argument. He had a relevance problem, thought maybe he got help from one of the lawyers writing it. Has to do with Christianity. Defense thinks it's not relevant. State argues it goes to motive and the victim targeting enhancement. We had that kind of temper tantrum from McBride where he insisted he had to talk about the substance, but then he was able to make his argument without quoting, reading directly from it. Of course, we had a long record. That conversation about religion and gender, do those things intersect? Religion and politics? Well, the legislature distinguished them, but, you know, it's not really a smooth distinction, is it? Oh, so we got this one, quote unquote, provisionally admitted. He found that it's relevant. So he found that it's relevant. And so we said, when it becomes relevant based on Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then he will decide he's not publishing it. But both parties can weigh in on that when this comes up again. So it was a situation, I think, where they were kind of dealing with it before it was really at issue. So the court's like, well, it's not necessarily the point to be making that decision. Provisionally, he's agreeing it should be probably should be admitted, should be published, but when it's the appropriate time, or should not be published, but when it's the appropriate time, we'll revisit it. And so it just hasn't come back up, but it's out there available to be revisited. So we'll see what happens with that too. Lax Forge, Andrea, you should ask Andrew to file that brief. Yeah, I wish somebody had filed that brief. It sounds like the state basically filed that brief. They didn't say the word Chandler in open court, but by talking about the subsequent history, that's clearly what they're talking about. And see, we can have faith in these lawyers, guys. They went far beyond what I did last night on the stream. They did a whole bunch of other legal research as well, gave that to the court, talked about, you know, the Sixth Circuit case. That'll be interesting one for me to go look at and add to my collection of things I keep track of relating to the law of public access. So I will probably at lunch, I'll check the exchange again, go in and refresh and see if those filings have hit the docket yet, so that we can get them up on the Substack and take a look. Ginger Puff 764, here we go. Day 4 with our girl Andrea. I have a notebook with notes like in school. Yeah, I'm on my 4th yellow legal pad myself. Glad that we're finding this educational. I mean, it really is. Really is important civics stuff. Lizzie Lil, just wanted to say, love your coverage and your hair and makeup is flawless, girly. You are too kind. You are far too kind, especially like when we are many hours in. I assure you, I've been something of an amateur photographer aspirant since like back in high school. I do. I love photography. I studied it for a while. There's actually a period of time where there was a fork in the road for my future. I applied to law school. And I applied to the Brooks Institute of Photography. Brooks Institute. It's down in Santa Barbara. It's a very, very famous art school for photography. The reason why I knew of them is because they house the Ansel Adams archives. They've got like all of his old negatives and things like that. I am a major fan of Ansel Adams. Lots of amazing photographers out there, but he's I like landscape photography, and so he's kind of the king of that in my eyes. So anyway, I could have gone a different direction, but I didn't. Went the law school route. But so, I'm not unfamiliar with the various tricks of the trade vis-a-vis photography. Certainly not at the level of the experts, but So all of this is to say, lighting, girl, lighting. It's really all about the lighting. It's all about the lighting. You can get the lighting nailed. It will be extremely forgiving of what I have to tell you is not a whole lot of skill and knowledge on my part when it comes to hair and makeup. I could use some of Erica Kirk's assistance. I really could. I'm one of those people. I get very stuck in a rut with the things that I do. All right.
We'll wait a moment for the public to be able to come back into the courtroom.
Just about back. My baffled brain, Andrea being a defense attorney and calling for court transparency carries so much weight for me. Tyler defense team's scare tactics are tiresome. I will say, my perspective has changed since I was a defense lawyer. I mean, when I was a defense lawyer, I understood exactly the position that the defense team is in. The press is usually 99% of the time not your friend. Nothing that they say is going to be helpful to your client, because most of the time in criminal court, the vast volume of cases going through, you're not dealing with innocent people being wrongfully charged. You might have other issues going on with the case. Maybe it's not the right charge. Maybe there's, issues with the consequences. But you're really not dealing with this problem a significant amount of the time, where I have somebody who's like actually innocent and did nothing wrong, and the state is trying to put him through the ringer, which is where, the Karen Reed example is a great situation. Shouldn't have been charged. And so the publicity is helpful to the defendant in that point, because I have a whole side of the story to tell. Most of the time, it's not like that. So my perspective on that has shifted. I'm wearing different shoes now as a commentator, and I'm seeing it through a different framework. And I do still understand where the defense is coming from, but I have a greater appreciation for how important it is to have an informed public about criminal court. I think about like how much better it is to have juries that understand the system. That's going to be better, having people that are informed about the process, how it works, what it all means, and everything. They can keep that all in perspective. So I don't want to take too much credit for I'm a defense attorney advocating for public access. It's not in my role as a defense attorney I'm advocating for public access. When I was a defense attorney, no comment to the press. No comment to the press. I think of one exception where it's basically just he's going to exercise his right to appeal, period. That's all I have to say. And we did. And he won, as I knew he would. But thank you. Thank you for that. Bass player 2011 IFY. Public trials doesn't just go back to the start of our country. It's inherently part of the common law. So shutting out the public goes against 5 or 6 centuries of precedent. Socrates was tried in public. Tried in public back in Athens in 3 something. I forget exactly what year. Forget exactly what year it was. Socrates was tried and executed not long after the end of the Peloponnesian War. Yeah, this is a long, long history. So yeah, it's not just us, but for our purposes, how we do things and have done things since the inception of America. Yeah, we adopted a lot of the common law, primarily from England. Long history of doing court in public. So your observation here, very duly noted. You are absolutely correct. We have a new YouTube member, Calseep. Welcome. Welcome to the channel. Thank you so much for your support. Bass player 2011 IFWay, still have faith in the judge? Yes, I do.
Judge, we were having computer technology issues, and we believe those have been sorted out, but we have not yet had the opportunity to show the final edited versions to the defense.
All right. Well,
thank you, CH.
How much time do you need?
Just as long as it takes to show the video. So maybe 10 minutes.
All right. Well, we'll go into, well, I want to make sure sufficient time is done to do that. I'm sorry, I didn't realize that we were at this point. We'll be in recess for 10 more minutes. So by 11:05 approximately.
10
That
more
should work.
minutes.
And also we can inform the bailiff as soon as we're done if it's ahead of that time.
All right. So ladies and gentlemen, I apologize. I thought we were ready to proceed. I want to be respectful of everyone's time, but all at the same time, keep this hearing moving forward. So court is in a brief recess.
All right.
Another 10. That's fine. That's fine. Whatever. Inherent delays in court. This is why, when you get called for jury duty, bring your book. And I know it's old school, but bring the paper one, because they do sometimes get a little persnickety about devices, and particularly with jurors, because they don't want people sitting there, investigating, reading up on the case that you're there being vetted for. Bring a good paper book, because there is a massive amount of downtime. But yeah, to get back to the last question, still have faith in the judge? I do. I trust Judge Graff's heart and his motive. That's what separates him, for me, from certainly a Judge Gold, who has zero interest in giving the defendant a fair shake. And it also separates him from somebody like a Judge Bev, who I think was well-intentioned. I do think Judge Bev was well-intentioned. I just think she was very, very blind to her own biases. It just was very apparent how much she didn't like the defense team and what different standards she was applying to both sides. Mr. Lally lies to the court with impunity and it's no problem. Mr. Jackson makes representations to the court about communications that are not, strictly speaking, inaccurate, but she feels it's misleading. And that's now a huge candor to the tribunal problem. I don't think Bev was malicious. I just think she was blind. I don't think this judge is blind, and I really do. I think that's why he's struggling. I think that's why he's having the hard time articulating his rulings, is because he knows he is struggling. But he has a job to do. So I do still have faith in the judge. I think he is really doing his best. He may not get everything right. I am not almost certainly going to agree with him about everything that he decides. But once again, here he is. Nobody gave a shit about us at home but the judge. And this is like the third, fourth, fifth time, something like that we've seen that from him. So yeah, I have faith in Judge Graff. King the Conqueror 2025 Novak, please shut up. Oh, his shine is gone for me. His shine is gone for me. So, yeah, I've been a defender of Mr. Novak, but I lost some respect for him with this this approach with SDs. I don't think it was. I don't think it was. It was disingenuous. I do. I know he knows. I know he knows that Estes was limited by Chandler. Not technically overruled, but effectively was, because we can read Estes for ourselves and see what it says. And it really did pretty clearly say it's a per se due process violation to televise a criminal trial, period. We can read that and see that that's what it says. But then Chandler was like, well, they don't want to follow that. It's a bad rule. It's a terrible rule. So they're like, it doesn't really say that. So they didn't really overrule it. They didn't say, we did decide that and that's wrong, and we now repudiate that and decide something different. That would be explicitly overruling it. But they just said, it doesn't actually mean that. It's only about its own case. So that means it doesn't apply. That reasoning doesn't apply to other cases. But I get it. I get it with Mr. Novak. I do. Lax Forge, how can it be both irrelevant and undue prejudice? Well, I mean, things can be irrelevant and unduly prejudicial. Classic example, prior bad acts of the accused. Somebody is on trial for domestic violence. Prosecutor wants to bring up their DUI from 20 years ago. It's not relevant. Is it prejudicial? Yeah, it's a smear job. It's literally there to just try to make him look like a bad guy. That's the classic example of it's irrelevant and it's unduly prejudicial. This we know isn't that, because it's about Lance. It's not about Tyler, it seems. So, like, there's not like an inherent contradiction with those two positions, but I agree. I am struggling to see how it applies to what we're talking about here, to the extent that I understand what we're talking about here, which is a little difficult when we don't get to see what we're talking about. Bass player 2011 IFYA paralegal finally did their job. Hats off to the paralegals, because somebody was up late last night doing a massive amount of legal research, putting together a brief. Hats off to them. Hardworking paralegals. They are the backbone of the legal practice. So I appreciate that. The Purnell 1799, Slovak effectively makes $500 an hour. I get this. I get this. We looked at parts of the defense contract. We've looked at during the recap streams. He's getting, all the defense attorneys are getting $223 an hour. This is the federal CJA rate for capital defenders. The CJA is the Criminal Justice Act. This is when the court has to look outside the federal public defender's office because there's a conflict, or they have too many cases. They don't have time to take on a new one. So they have to hire a conflict attorney, basically. And this is what CJA attorneys are. So they are private attorneys. They're not employees. They're not salaried. So they get compensated at an hourly rate. That is set at $223 an hour for capital cases. Pretty low by lawyer standards, but I get what you're saying. If you just take twice as long to say what needs to be said, you're effectively giving yourself a raise. User XR numbers. Why did Erica wimp out? Gallery only, really? I think the victim's representative, the attorney, I do think they did a smart thing. which is to really keep it focused on her and her interests, instead of like trying to kind of elbow in on the media's job is supposed to be about us. I take issue with the media. I think it's perfectly appropriate for them to make an argument that's geared around her right to be present. And her right to be present doesn't really implicate the cameras one way or the other. My issue is with the media lawyer saying, fuck all you people at home. My clients are sitting here in the courtroom. They're going to be able to take notes. So those of you who want to see for yourselves, you can buy a subscription to the Deseret News to find out what happened. You can buy a subscription to the Salt Lake Tribune. You can, get behind the paywalls, whatever. I don't like that. I don't like the exclusivity that provides. Because now we're making the court proceeding, a not just an asset, but a limited one, a very finite one. And that's not how it's supposed to be. There's lots of law. There's like the copyright law about access, again, to court proceedings. Can you copyright your court filing? No, you can't. No, you can't. It's not in the public interest to do that, because court records are public. We should all have access to them. There should be no restriction on our ability to share them. So it's a similar kind of idea. If you're giving the media preferred special access to stuff, they're going to be able to, market that and benefit from that the same way they could as if they could copyright this stream, which they cannot do. So my beef isn't with Erica on this at all. I think her argument, her lawyer's argument, was tailored to her specific interests. That is appropriate. It wouldn't really be good for her to get out of her lane and to start speaking on behalf of the entire public. That's supposed to be the media's lawyer job. He didn't do it. I'm going to remember that. It's not the first time we've seen that either. Johanna, 81-524. I don't know if it's Johanna or Johanna. Sorry about that. At this point, just publish everything. They said admission so many times that the effect is the complete opposite of what the defense wants. They couldn't have made it clearer that this is Tyler Robinson saying some really incriminating stuff. However you characterize it. Couldn't have made that clearer. That point has been emphasized many, many times. Looks like we're going to get to see it. All the texts. The real CH3. At what point does the defense's constant fighting to not televise a confession hit Streisand effect territory of telling everyone watching that the confession exists? I think we might have passed that point. Might have crossed the Rubicon there. I'm not sure the disclaimers from yesterday about we don't really think it's a confession, but the state's going to say it is. I don't think that is going to save them from this. If you're going to live by litigating press, publicity, public access, then you are going to die by litigating it as well. And that is the risk. We talked about that when they were doing the motion to exclude the cameras, and they filed like, I don't even remember, 100 some pages of different media articles and things like that. And they wanted it under seal because of that. And the media pointed out, they're newspaper articles. They're already public. You don't have a good justification to seal it. So now what we've done is draw a lot of attention to all the things that you're saying is prejudicial. Yeah. I feel like we're past that point. The point has been made. What difference, Mara W8658, what difference does it really make to the jury pool if the lawyers are publicly referring to a confession in evidence? would that not taint the jury if you were to follow Mr. Novak's argument? Unless you really buy into his qualification there, well, it's not really a confession according to us. It's just what the state is going to call it. And again, I have some sympathy for this position because that's what happens a lot of times. Things get characterized. I've been talking about the way that Mr. Agent Hull is characterizing the distinctive wheels on the car. Distinctive is a characterization. Okay, it's not like something that's factually observable. It's your opinion about it. It's your judgment of it. But so there's no right or wrong. It's not like you can prove or disprove that something is distinctive. You can just kind of argue it based on different things. To me, these don't look distinctive. They look a lot like the stock wheel on a certain trim for certain models of Dodge Challenger. So I don't know why you're saying this is distinctive. And they will often do stuff like that. You know, they color it. And often it's because I might not reach that conclusion if I just look at it myself with my own eyes. So they have to try to prime me to see it a certain way. Normally, the best way to convince a jury to your side, show, don't tell. Show, don't tell. Let the jury reach its own conclusion, because if your evidence is good, they're going to see it the way you do anyway. And so it's, to me, it's always a tell when they're like, we want to characterize this a certain way.
President Trump's lead.
Not just give you the facts and just the facts, but also load it up with what we think about those facts and how we think you should see those facts. I mean, that's argument, that's fine. But it's just this very underhanded thing to do, to like present it in testimony as though it's a fact when it's not. So I do get that. It's a little bit of a distinction in this context because, you know, admissions and confessions, these are things that have formal legal meanings. They have, you know, significance in the decisions the court's making about admissibility. But
noting the presence of the parties, all being present, and where we left off is we were looking to, the state was looking to confer with defense to ensure that state's exhibits 16, 16.1, 16.2, and 16.3 were shared. Ms. Hunt.
We have reviewed Exhibit 16 with defense, and it comports with the court's order. At this point, we would like to put Agent Davis back on the stand and continue with displaying that, publishing that.
All right, Agent Davis, if you'd like to come forward, I remind you, you're still under oath. If you'd like to have a seat, there should be a water bottle to your left.
Exactly, you get what I'm saying.
If you wouldn't mind adjusting that microphone and bringing it close to you so the record can pick up your testimony.
Tell me what's distinctive, not just that it is.
And just for the record and the court's benefit, we have made the edits that the court has ordered. We have shown them to defense. Pursuant to the timestamps that the court ordered, we wanted those to be reflected very clearly. So there are sometimes large gaps of just black, empty, silent space. When there are large gaps, we will fast forward. Some of those are short enough that we'll just let it play if the court is okay with that, with proceeding that way.
Thank you. I appreciate giving a heads up so all parties know what's going on. Thank you, Ms.
Forgotten what he
So
looked
at this time, we would move to publish on the monitors State's Exhibit 16.
All right. And to the media, there is a monitor for your benefit right there next to you. For the camera, there is one for.
So we're not audio only now, too. It was going to be audio only, but no, we're going to get to see it. This is why I continue to have faith in the judge.
This meeting is to use your statement here instead of your testimony at a preliminary hearing. Understand that? Mm-hmm. Okay, so in order to do that, I need to place you under oath and also give you an admonition about false statements. Okay. First, you do solemnly swear or affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
I also need to notify you that you are notified that statements you are about to make may be presented to a magistrate or a judge in lieu of your sworn testimony at a preliminary examination. Any false statement you make and that you do not believe to be true may subject you to criminal punishment as a Class A misdemeanor. Understand that?
Yes.
It potentially could be used as for punishment as a higher offense as obstruction of justice. In addition, I just want to make sure that our recording here is clear that you've also been given a federal agreement and a state agreement granting you immunity from prosecution for materials that you discuss now. You understand that?
Mm-hmm.
Okay. First, we're going to cover some of the things that you've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do. Yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Okay.
And will you describe your relationship with Tyler when you first met him anyway?
When I first met him, I didn't know him super well. He was just a new roommate. So I knew he knew my friend group and I knew he liked playing games, but that's about it when we first, when he first moved in.
Okay. Before we go on, I realized my mic was muted at the outset. Was yours on? Your microphone?
No, it's a major record.
I'm going to repeat those admonitions just to make sure we got it recorded. Okay, so again, I place you under oath. Just to make a record, I'm going to do it again. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And again, I'm going to give you the false statement admonition.
Sorry, hold on. They're saying that it's echoing. So
She's aware that
this one's mic is on.
Okay, sorry.
Okay, you don't own my mic,
but that's fine.
Okay.
Okay, so we should be good. All right.
It's echoing on the recording.
Is that mic on?
Yes.
Okay, great. All right. Okay, sorry about that interruption. All right, so you said when you first met you were roommates?
Yeah.
Okay. And then at some point, your relationship progressed to something more than just roommates, is that right?
Mm-hmm.
When was that?
I think we started dating 2 or 3 months after he moved in.
Okay. And where did you live at that time?
St. George, in an apartment complex.
And is that apartment the same place you lived when on September 10th?
Yes.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
No, separate rooms.
And at that time, let's say September of 2025, what were you doing with your life? Were you working, school?
I was working. I was doing like bathtub and shower repair and stuff in new construction.
Okay. How about Tyler?
I think he was both working. I think he was working for an electrician company then, and he was also in a trade school for being I don't know, higher ranking electrician. I'm not sure how the trade system works for that.
Okay.
But yeah, I think he was both.
What was his typical work day like?
I think he'd leave around 7 generally and get back around 3 to 4, depending on where the job was and how long it was for the day. And then on certain days of the week during school, semesters, he would then later in the day, I think around 5 or 6, go to school. So, yeah.
Okay. Let's jump to September 10th. Did he spend the night in the apartment the night of September 9th into September 10th?
Yeah, he did. Yes.
Do you know when he left the apartment on September 10th?
I don't know an exact time. I just know he left early. I heard him leaving, and he just said he had a long drive to work that day, so he was leaving early.
Okay, so early. Any guess as to what when that was?
I don't know. I would have thought it was 5 a.m. because that's when like an early work day was for him, but it was probably more like 4.
Okay.
I'm gonna spit out his gum just to make sure that
I can do that.
You're right in front of your laptop.
There you go.
Thank you.
Having him spit out his gum, poor guy. His comfort gum. I do understand that. I don't really like gum, but like the mint or something. Altoids, love the Altoids.
All right, so what time did you get up on September 10th?
Probably like 12 to 1 p.m.
You didn't have to work that day?
No.
And did you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that like automated message.
Okay, 11 p.m.
Yeah.
Thank you for skipping through the blank edits. (11 p.m. on the 10th). The automated message.
What about, he asks you here, remember how I was engraving bullets? Was he engraving bullets before this?
Yeah, I don't remember exactly when, but he had said he was planning to go hunting with his family. And he asked me for if we had a Dremel because he said he wanted to engrave messages on bullets. And I just told him where a Dremel was and told him to make sure he doesn't set off the bullet on accident in the house. But I didn't really think about it until then.
How long before September 10th was this that he asked about the Dremel?
I don't remember because he'd been talking about the hunting/camping trip for a couple months. But I don't remember when he was specifically asking to engrave the bullets. So
are we talking like a year before?
Oh no, not that long. It would have been I'd say at most a month before this was when he was asking.
Okay. Okay. Right. You talked about the note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is Bates number 58. Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay, so where did you find this?
On his desk underneath his computer keyboard.
And I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
Right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
And now I want to go to what's been titled 16.2. And do you recognize this series of messages here?
Yeah, that was the server of like his friend that I was mentioning.
Okay, and this is your phone again?
Yeah.
Here. And I'm assuming you recognize it because the big crack up at the top.
Mm-hmm.
And so this is a server. Is this Discord?
Yeah, this is Discord.
And who are members of this server? I don't want names, just generally, who are these people?
This is his friend group. They played D&D together every week.
Okay. And I just want to scroll through this to make sure that you get a chance to take a look at it. Or go to the next page.
Mm-hmm. Or yes.
So Tyler Icom, who's that?
That's Tyler Robinson.
These other people are just others that are members of the server.
Yes.
Jug, Barnaby, Marina, DM.
Mm-hmm.
I missed the username for Tyler.
Like DM means Dungeon Master. So this is these are like most of them are names they're using in the game they're playing currently.
Got it. Yeah, it looks like the last text from Tyler looks like it's 8 p.m. And do you know what day this would have been? 8 p.m. on the 10th or the 11th?
I would think that would be the 11th. Because at least I think so, because I don't think on the 10th that he messaged anyone before me at like 11. So.
And he turned himself in on the 11th, right?
I thought so, yeah.
So again, we're just going to go through this so that we have a record of the messages. Is that an accurate recording of that thread?
Don't gaslight us.
Knowledge, yes.
Blessed mom from Texas.
And that was sent.
She said it many times.
September 10th and September 12th. Looks like the last day.
The fact she's not consistent about it doesn't mean she didn't say it.
Yes.
Otherwise, I'm not going to talk over this. We just confirmed it was the 11th.
Okay. All right, so again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time did you see Tyler on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting.
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I think I saw him after that message where I said I'll come home and say I'm doing laundry, because I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home.
Mm-hmm.
And did he talk about what he had done?
didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. I started crying a little bit and said he wishes he hadn't done it. And then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
Okay. Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat, but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images. Okay, I'm on the FBI's website. You can see the URL there at the top. This is some press release about this event. And here on the screen, you see these, looks like there's 2 rows of 3 images. Do you recognize the person in these images?
I wouldn't say with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So it definitely, especially the bottom, the last 2, definitely do look like him. Oh, they do look like Tyler Robinson.
And you talked about that with your friends, right? This like him.
Yeah, his friends. Yeah, I don't know if I don't remember if I talked about it with any of my friends. And then since I didn't have my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
Okay. All right, I want to back up a little bit now. We've talked about September 10th, but let me get a little bit of context here. So, did you game with Tyler?
Yeah.
What kind of games?
Played some just kind of party games together, like anything that would be multiplayer with a group of friends. There was one game he really liked called Sea of Thieves, where you play as like a pirate, and you can fight against people, but most of it's just like fishing, fighting sharks, skeletons kind of stuff. We played some co-op games where it's like you both have to work together to win in whatever way. Way back when I was just out of high school, when I first knew him online, we played some shooting games together, but I didn't know him very well, so that was just when we had a whole friend group on to play, and he was someone that my friends invited.
Okay. Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did you ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay. How about political issues? So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current like policies being like issued or voted on, I think. But yeah.
Okay, so before that you have been?
For a short time, yes.
Okay. And I understand you're going by Luna at some point?
To some people, yeah, but not as an overall thing.
Sure. Okay. I think that's all the questions I have for this portion. Let me check and see if I've missed anything. Okay. The Dremel that you talked about, you said he had asked for that, is that right?
Mm-hmm.
And had he told you it was to inscribe bullets?
Yeah.
And so did you have a Dremel then?
Yeah.
Okay.
It was in our, like, our apartment, we had a section where we kept all our, like, random tools for household stuff in our, like, lower basement level pantry. So, yeah.
Okay. And did you give that to him or tell him where it was?
I just told him where it was, yeah.
Okay, I'm going to go ahead and end the recording for the 1102 purposes.
All right, that concludes State's Exhibit 16. Ms. Hunt.
Thank you, Judge. Agent Davis, I asked you yesterday, but I want to remind the court and those present. Were you physically present at the interview we just watched in State's Exhibit 16?
Yes, I was there.
And aside from the court-ordered redactions, did it appear to you to be fair and accurate about what you remember that interview that day?
Yes, yes, I do.
During that interview, did Mr. Twiggs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, a Discord chat messages, and a handwritten note.
And then we also saw in the video, he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
Have you reviewed all of those items as part of the investigation?
Yes, I have.
You're familiar with them?
Yes.
All right, I want to put just on the witness's screen what's been marked for identification as State's Exhibit 16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
I see it. I see it now.
Do you recognize this?
Yes, I do.
What is it?
This is a photograph of screenshots of text messages between Tyler Robinson and Lance Twiggs. This is a photograph of Lance's phone.
So sorry, you said photograph, you also said screenshot. Can you differentiate or clarify there?
Sorry. These are photographs directly from Lance's phone.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time his phone was photographed.
And you testified, I believe yesterday, that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at a picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
And you kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th, he physically, he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview he refers to the large crack in the upper left screen. That so he identifies that from his second interview that was given on April 20th.
And according to your review of the recording of his first interview and in speaking with the agents that were there, did he have his personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview sorry, let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twiggs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
Is State's Exhibit 16.1 a fair and accurate representation of the text thread or the relevant text thread between Mr. Twiggs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twiggs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twiggs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
All right, Judge, I would move to admit State's Exhibit 16.1, and then pursuant to court order, I would move to publish it to the monitors.
Mr. Novak.
We have no further objections beyond those that the court,
thank you,
of course, is very familiar with at this point in time.
All right. I'll note the standing objections made by defense. Those objections are overruled. This 16.1 is admitted into evidence and may be published to the gallery as well as electronically distributed through the camera.
All right, Agent, I'm not going to go through every single message, but I do want to have you read aloud certain portions of them. And I apologize to counsel, these are not actually given a page number. I have page numbers, but I'm happy to confer that we're on the same page as we go.
Drop
So
what you
here
were
we're looking
doing.
at page 1 of State's Exhibit 16.1. If you could read a little more than halfway down where it begins Wednesday, 11 p.m., will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize. Let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just with iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
We could scroll down to page 2. And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
We could scroll down to page 3.
Camera guy.
Continue reading.
You're losing the
Lance
assignment.
says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, or sorry, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading.
So far, nothing is new.
About halfway down, I'll stop you about halfway down.
This is while they were a spot, but I don't want to chance it while they were parked there. If they'd found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there. Let's move to page 5. So this should be page 4. So just scroll down 1, please, Kimberly. And if you could read starting sorry, Kimberly, scroll a bit more down. If you could read, I don't know, about a 1/3 of the way up that starts with guess.
Okay. Tyler says, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off.
And continue.
And Lance says, are you okay still? And Tyler says, yes, check and spot again now.
Sorry, now we're on page 6. Continue reading.
We'll update soon. He continues, the squad car was moved further away enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so fucking loud.
They were.
Gonna see if the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be in the wrong spot. Lance says, do you think they found it? And Tyler says, dunno, they haven't published anything if they have. And then Lance says, why did you leave it behind?
Oh, sorry, Kimberly, if you could scroll down.
Camera guy.
Originally. Also, does it have a serial number?
We could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if it had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with.
And stop there, please. And then if we could go to the next page, page 8.
Camera guy, you fucking suck. Fire this guy.
Okay, so Lance says, was your change of clothes there or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun or would he notice? Then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it was old as shit and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm going to have to leave it. That really fucking sucks.
Let me stop you there. And then if we could go on to the next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes. So Lance says, do you need it for hunting? And Tyler says, no, my a 2K scope. Lance says, geez. And then Tyler says, OMW home, 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15.
Camera guy, get with the freaking program. I hope he gets fired. Fire this guy.
And then the second grade message on page 15, if you could start there.
Okay. So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Okay.
And we can remove the exhibit from the screen. Thank you, Kimberly. We mentioned a Cellbrite extraction of Mr. Twig's phone. Do you know what time that last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
I'm sorry, September 11th?
Yes.
Would September 12th make sense? Or you're saying September 11th?
So September 11th was when he turned himself in. Okay. Would have been September 11th. Yeah.
Okay. Thank you.
Yep.
All right. I'm going to show just for the witness States Exhibit 16.2.
It was. They've testified about this. They took it, extracted it. He's testifying about it.
What is it?
This is just more photos of Lance's phone. And these are these are sorry, I had to blank. Sorry, go with your question, please.
I'm just asking what it is. So you said it's a photo of Lance's phone. Do you know if that's from the same time period as the exhibit we just looked at?
Yes.
And what is it of?
These are the Discord messages of that Lance had talked about.
How do you know that?
So Lance, in the first interview with FBI, shows the phone. The photos are taken by Agent Larson, and then these images are shown to Lance during a second interview, and he confirms that these are those same messages, and this is photos of Lance's phone.
You mentioned an Agent Larson took the photos. Do you know if he's the same agent that took the photos of this exhibit 16.2?
Yes, same agent.
And you spoke with him to confirm that?
Yes, I did.
Are you aware if Mr. Twiggs is actually part of this Discord thread?
Yes, he is a part of it. He doesn't, in this section, he doesn't reply to it, but he does state in his statement that he was part of that thread.
Does he identify whether Mr. Robinson is part of that thread?
He does.
And when did that happen?
He identifies that in his first interview with the 2 FBI agents, and then he again confirms that in his second interview.
Did Mr. Twiggs say what username on Discord Mr. Robinson used, at least with respect to this thread?
Yes, it's the Tyler/Icum, IKUM.
And is Exhibit 16.2 a fair and accurate representation of that Discord thread?
Yes, it is.
Tyler Icum.
Did law enforcement send, as part of your investigation, did law enforcement send a subpoena to Discord?
Yes, they did.
Were these messages recovered via that subpoena?
They were.
Did you review that?
Yes, I did.
And in State's Exhibit 16.2 that is before you, when is the first message from Tyler sent?
7:57 p.m.
And it says yesterday. Do you have any knowledge of what day that would have been?
Yes, this would have been September 11th.
So Tyler sends the first message that you're seeing on Exhibit 16.2, September 11th at 7:57 p.m.
Yes, that's correct.
You testified earlier that Mr. Robinson arrived at the Washington County Sheriff's Office approximately at 9 p.m. Is that right?
Yes, that's correct.
And although you weren't physically present there yet because you were flying down, how do you know that he arrived approximately around 9 p.m.?
Just based on the police reports I reviewed and then go back and look at the video and such.
Judge, the state moves to admit State's Exhibit 16.2 and publish it pursuant to court order.
Mr. Novak.
Thank you, Aaron. We've already lodged all of our objections on all 3 phases.
All right. Noting the objections, standing objections by defense. State's Exhibit 16.2 is admitted into evidence and may be published only in the gallery, not for distribution on electronic media.
So what happened to the duplication? Cumulative. And now the judge is muted. Well, if the media does as well reporting this as the camera guy did, we won't learn anything. This is what's interesting to me, too. No obvious red flags in any of it. Usually crime is grouped. Same neighborhood, same family, same, cross generations. People are perps one day, victims the next. Seems to be very much an outlier. Definitely isn't duplicative. Nobody's allowed to live tweet because they aren't allowed to have their devices in the courtroom. No laptops, no phones, nothing like that. So there will be a dash.
I see it.
To do it.
Do you recognize this?
I do.
Break.
What is this?
This is a handwritten note or letter from Tyler to Lance.
How do you know that?
In Lance's first interview with FBI, he tells them about this letter note he found under Tyler's keyboard per a text message he received. He states from 11 p.m. on September 10th. And so at that point, Lance finds this is the letter he finds under that keyboard.
Okay, so to clarify, Mr. Twiggs gets a text from Mr. Robinson around 11 p.m. on September 10th, telling him to look under his keyboard.
Yes, correct.
And this is what Mr. Twiggs represented was underneath the keyboard.
Yes, yes.
How did law enforcement get this photograph?
So following Lance's first interview at St. George PD, his phone is recovered at that point, taken into evidence. It is downloaded, I believe it was the following day or shortly after that. The FBI transported that phone to the RCFL, which is the Regional Computer Forensic Laboratory in Salt Lake City. The phone was downloaded through Celebrite, and after that, following that download was complete, SBI received a flash drive containing that download. From there, it went to a SIAC analyst to go through that data of his phone to look for any pertinent evidence or information that may be on there. And at that point, that this image of this letter was located.
All right, I'm going to break down a few things. You mentioned, just want to make sure the record's clear. You mentioned Celebrite a few times. What is Celebrite? It's
a downloading software that's commonly used by law enforcement. I don't do that myself, but it's commonly used to recover data to download electronic devices, particularly cell phones.
And then you mentioned SIAC. What does that mean?
It's the Statewide Information Analysis Center. It's a division within DPS. That's a fusion center. They assist law enforcement with intelligence, various intelligence information for our investigations.
You mentioned that you don't personally do Celebrite phone extractions. Have you spoken to the law enforcement officers that performed the Celebrite extraction on Mr. Twiggs' phone in this case?
I don't believe I specifically talked to those individuals, RCFL, that did that. But they, that was then provided to SBI.
Did you speak with officers at SBI that have recovered this photo that we're seeing in State's Exhibit 16.3?
Yes, I have spoken with an SIAC analyst who in particular found this image. I've spoken to her personally as well.
Was Mr. Twiggs shown what's been marked as State's Exhibit 16.3 during his second interview?
Yes, he was.
And again, you were present for that?
Yes, I was there.
Is Exhibit 16.3 a fair and accurate representation of the photo law enforcement obtained from Mr. Twiggs' phone and that he was subsequently shown in the second interview?
Yes, it's fair and accurate.
Your Honor, the state would move to admit Exhibit 16.3 and then also publish pursuant to court order.
Mr. Novak.
Just noting the objections that have previously been made, and I think that the court's order is that it may be published in the courtroom only.
Thank you. Noting the standing objection by defense, 16.3, correct?
Correct.
Is admitted into evidence and may be published only in the courtroom and not be shown or videoed.
Just sit back and enjoy your secondhand citizenship here for a few minutes.
I do.
What is it?
These are the images that the FBI released to the public. It would have been on September 11th when those were released. And this was, those are those images that went public of the suspected EVU shooting suspect.
How do you know that?
I've viewed the FBI's website, and I recall seeing these images released on September 11th.
Does State's Exhibit 16.4, is that a fair and accurate representation of what you reviewed from the FBI and that the FBI released?
Yes, it is.
The state moves to admit Exhibit 16.4 and publish according to court order.
Mr. Novak.
No further objections. Thank you.
Right. Noting the standing objection by defense, overruling that objection, State's Exhibit 16.4 is admitted into evidence and may be published in the courtroom.
And again, in the Discord.
Seriously, we don't get to see the FBI news release? Literally a public release. It's still up there on their website. This is over the top. They're like having argument and stuff. We're not getting to hear this? Is this coming from the court or the camera that this is muted? Learning my lesson here about trusting the live stream instead of going there in person. Where are you? Where are you? Somebody, anybody? Hello? Bueller? Bueller. Don't rely on them. Unreliable. Consistently. If your expectations are low, they're not low enough. Court TV, I'm seeing. Switch to Court TV. Let me see if I can find it real quick. All right. Court TV seems to also be muted. Yeah, they don't have sound on Court TV either. So it's the feed. They have the feed muted. And I don't know if that's because the court is saying they have to or because the cameraman has fallen asleep at the switch. Not hearing legal arguments is a big problem. Without any kind of closure argument is a problem. Depends on if they're going to have to do the thing where they redact it and then release it. A month? Couple months? The October 24th hearing we got sometime in December, if I remember that timeline right. Yeah, I mean, I'm left to assume the judge is well aware of what happens on the screen. So he knows. They all know. They're well aware that we're not hearing anything. It's on purpose. This is particularly stupid because people are in the courtroom. It's not like they closed it. They didn't kick everybody out of the courtroom to have this argument. CH looking on the bright side here. According to KSL, it's muted by order of the judge. This is insane. This is insane. This makes zero sense. No logic to it. If they're having this conversation in front of the audience, then there's no reason why we shouldn't be hearing it. You're making it harder for me to defend you, Judge.
As it relates to 5.1, the court previously, the day that I did it, I believe it's day 2, perhaps.
That sounds correct.
The court provisionally admitted it, contingent on additional foundation being laid, whether through testimony or through evidence. The court notes that such foundation and testimony has been laid in order for the foundation to be laid for 5.1 to be admitted into evidence for full consideration by this court. And so that is received. As it relates to publication and taking in consideration the argument by Mr. Novak, well, first noting the objection, the standing objections by defense, that is overruled as it relates to the admission to 5.1. But going to the publication, the court understands the argument made by defense that this is going toward perhaps religion, and that the enhancement, and let me just read that from the information, victim targeting enhancement in violation of Utah Code annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. And that was also noted as an enhancement for count 2 and count 7. The court is not going to engage, the court can weigh how this is applied, but it finds it relevant, whether how it relates to the enhancement is for the court to weigh as it looks at the bind-over decision, and it's not engaging in that decision-making today, but finds that it is relevant, it is admissible to the court, and is publishable to the gallery as well as to the public. And so if the state wishes to publish State's Exhibit 5.1, it may do so at this time.
Thank you. Yes, we do.
Oh, Lord.
And Kimberly, I don't know if we want to use the same kind of slow scrolling. Thank you.
Slow scroll. Well, no, Kimberly. This is hard to read. Somebody needs to turn up the contrast. You were so close, camera guy. I can't read this in real time. Can't read it in real time. Can't read this at all. This is the 1102 statement they talked about before from Mr. Englehart, somebody who's associated with Turning Point USA, pastor, friend of Charlie.
All right, I believe that should be sufficient. And Agent Davis, I apologize. I'm going to take you very briefly back to State's Exhibit 16.1, which is the text thread between Mr. Robinson and Mr. Twiggs. Kimberly, if you could turn to page.
It pertained to Charlie's beliefs on
17.
Orthodox Christian views, which we presume to be
this has
on
already been admitted,
gender and sexuality.
Court, correct me if I'm wrong, published not only to the gallery, but to cameras at large. I'd ask that it be displayed in that fashion again.
All right. Any input from any other party on that request? All right, thank you. It may be published, and the media may pick this up as well.
Agent Davis, if I can direct you to the very last message on that page, starting with "if any," if you could read that out loud.
Okay. This is Tyler. It says, if any police ask you questions, sorry, let me start over. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure the police follow.
Okay, thank you. That's all I need from that exhibit. And then finally, Agent Davis, you testified before that you flew down to Washington County Sheriff's Office and observed Tyler Robinson there, correct?
Correct. Yeah.
You got his name there?
Yes.
You stated that you transported or assisted transporting him up to Utah County Jail?
Yes.
And that you were the booking officer?
That's correct.
Do you recognize Tyler Robinson here in the courtroom today?
Yes, I do.
If you could point him out and briefly describe something that he's wearing.
He's an individual seated at the defendant's table in the center chair with a gray suit coat and a green tie.
Your Honor, if record could reflect identification of the defendant.
Counsel?
No objection.
All right. I'll note for the purposes of this hearing only that Agent Davis has identified Mr. Robinson in court. Thank you.
And Judge, if I can just have a moment.
You may.
Ready to pass the witness. Thank you. And I don't know, now would be a good time for lunch.
Going to lunch.
All right. We'll go ahead and break right now for lunch for 1 hour. We're on 1 hour and 5 minutes. Let's come back at 1:30. We'll resume. We'll pick up the defense for cross-examination if they choose for Agent Davis. Does either party need the benefit of the record before we go on our lunch break?
Not the state.
I have no cross-examination for Agent Davis, so I don't want him to wait here if he has other things to do.
Thank you.
Thank you, Mr. Novak.
Thank you.
No cross-examination.
No cross.
May this witness be excused.
Yes.
All right, Agent Davis, you may step down, and then we'll resume with the state on their next witness. Court is now in recess.
All right.
No cross of Mr. Davis. No questions about the provenance of any of these things. No question about the timeline of any of this stuff. Nothing. Nothing. Oh, I'm like in a little bit of a like letdown from that rage energy. That was some bullshit. What's up with that, Judge? Now you have arguments in open court in front of the audience that we don't get to hear? Yeah, somebody needs to be getting that transcript. Zero justification for it to be public, to be private. The whole proceeding was public. That's annoying. Really super annoying. We get the end result. They are clearly, it seems, at least some of what they were doing was arguing more about the 1102 of Mr. Engelhardt went in favor of admission and being able to see it, but we've got a Mr. Potato Man camera operator over here. Couldn't figure out how to make it legible. So really couldn't see what it said in real time. In real time. I know people are going to do what they need to do to screenshot it, enhance it, and make it available and stuff like that. So it likely will be out there. But I'm just not over this. How are you having an argument in front of the audience in open court that we don't get to see? I already don't like this displaying things to the courtroom, but not to the cameras. We are not second-class citizens, Judge. We matter too. What on earth is the reasoning behind this? What's the reasoning behind this? If you want to create an absolute circus at your courthouse because people realize, oh, I need to be physically there if I'm going to get to see what's going on, this is a great way to achieve that. If we can't trust that we're going to get the information from the stream, we have to be physically present in the courthouse, then there's going to be one hell of a scrum out there. And I hope your small county is prepared for that. Oh, I don't like it. Doesn't bode well. Hope this is a teaching moment. Really do. What a mess. What a mess. Yeah, I'll order the transcript. Making a note right now. Very disappointing. Very disappointing. Oh, bass player, 2011 IFY. For those questioning the pre-written ruling, that's how this works. What we just watched was to get everything on the record. Yeah, how did you like that? The judge already had his decision made about what was going to happen with, the request to publish all the exhibits and view, all the exhibits and everything. He'd already made up his mind. The argument didn't mean anything. Just a chance. Now, in fairness, I wasn't like scrutinizing the judge to see if he was doing what he does, which is being very attentive to the parties. Does make it look like a kind of pointless formality, doesn't it? Gingerpuff 764. Andrea sent warrants I found, working on locating others when I can. Thank you for that. Very much appreciate it. I will not be getting those right this second. We got a few things going on right now this week, but I will definitely get to that very soon. And I really, really appreciate you sharing that with me. Michelle C's 9170. I haven't had a desire to go look at all of these videos and texts, but now that they're being held from view, now I want to see them. Right? Right? Streisand effect. It would have been just one more thing over the course of this hearing, but you blew it up. You made such a big deal out of it that you drew everybody's attention to it. Rage Bronson, take my money. Well, if you insist, we'll try to go do some good with it. We'll try to get ourselves some court documents, some court transcripts, whatever we need to do to get the clear picture of this process that's happening. User, XR and numbers. The defense should want this in the record because it gives them the ability to face Lance with gotchas at trial. Perhaps prosecution does not need it. I mean, okay, so we got a little bit more than we were expecting to get at the end of the day yesterday, right? Still big chunks taken out. But that's in part because we got to see the texts themselves. At least some of this was about just reviewing those text messages. And so that was cumulative. We got to see the messages themselves. So we didn't really lose too much with that. There were some other small things we didn't get to see. I think it's pretty clear from what's, again, already in the public record, the part that they omitted where they were talking about, so they went through the texts, and then I gotta find where in my notes all this stuff is. Tyler was at home. He was like walking around to distract himself. This was right after Lance says he started sort of crying. Tyler started sort of crying and said he wished he hadn't done it. That's pretty incriminating. And then there was, and so then he was walking around and it seemed like that was to kind of distract himself. And then there was, a pause, part that we weren't allowed to see. And then eventually he said he'd talk to his parents and turn himself in. And Lance himself, he didn't want to be at the apartment. It's pretty clear this is the self-harm stuff that was it's already public. We're already well aware that he was saying these kinds of things, or at least it's alleged that he was saying these kinds of things. So I think it's pretty clear that's what that's about. Why we don't get to hear it when it's already public, I don't know. So I'm trying to look on the positive side. I really am, because I'm still a little raging right now. I'm gonna have to take my own little step away from lunch. Get some tree vibes. Go get the piece of the bonsais. Check in on my little leafed out babies. Calm me down a little. I'm trying to look on the bright side because we are very much in a better position today than we thought we were going to be at the end of the day yesterday. The end of the day yesterday, we were just going to get audio and really open question about all these other exhibits and stuff. So we are in a slightly better position than we were. But I'm not happy about this muting. I can't get past that. I'm not happy about muting an argument in open court. Yeah, so the thing is it doesn't matter if this is in the preliminary hearing record or not for purposes of being able to use it against Lance. They have the exhibit itself, 16.1. That's all that they need. They're going to have his prior interview too. If it was recorded by the FBI. The defense has that too. The prosecution has that too. So it's already going to be available to use it for that purpose. They didn't want it in this hearing because they didn't want us to see it. Really the bottom line. Oh, we have LSP. G2G. Welcome to the channel, JSP. Appreciate your support. Happy to have you here with us. Amy Abati, I'm old. Can you tell me 1, what is Substack? 2, is it easy to use? 3, is it okay on a phone or laptop? Substack, they describe it as an email newsletter service. It's a subscription service to get content in various formats. It is available phone and desktop kind of some different functionality depending on which one you use. Is it easy to use? For the most part, I think so. I would say from the creator side, there's plenty of things I don't love, but I think from the reader side, from the subscriber side, it is pretty easy. What it does is you subscribe, you can sign up to get things emailed to you. So I will write articles, I will post videos. I have the legal document archive. It doesn't send emails when it's updated. That would be super obnoxious because that's really common. But as soon as I like post something originally, like I post that I'm keeping a legal archive, you'll get notified of that too. But you can also opt out of emails. You don't have to get them if you don't want them. So it's just a way to alert you to the fact that there's new content on the platform. So yeah, it's just a subscription service for content. Feel free to check it out. QR code will get you to the legal archive for this particular case. So take a look and see if that's something that you would find to be helpful, and feel free to sign up if you want. There is a paid subscription option, but it's not mandatory. I put plenty of stuff out. The archive is not paywalled. I put plenty of stuff out that isn't paywalled. I do occasionally put paywalled stuff out. Often if it's just a little more like personal, more stuff that like I'll talk to subscribers about, but I'm not necessarily like looking to shout out to the whole world. Sometimes when it's like I have something that I want to talk about that I don't want to, like, for example, alert anybody about how I see this problem so that they can work around it, kind of deal. But for the most part, I try to keep stuff as open and accessible as possible. That said, if you're inclined to support, very much do appreciate it. But that is totally up to you guys. Kang the Conqueror 2025. When is the right time to file a defamation suit? Within the statute of limitations. Within the statute of limitations is an important thing. And that, of course, depends on the law of the jurisdiction where the defamation occurred. That is sometimes a complicated legal question, but usually it's 1 or 2 years from the date of the statement. So the right time is before you lose the right to do it. Otherwise, it's a strategy call about what you think is best. To Truth for Liberty. Why would they authenticate messages using questionable credibility of an immunized witness rather than going to the direct sources of the electronic information, which is easy to subpoena? Well, this may have preceded the testimony about the fact that they did in fact do those things. They're not offering the Celebrite and so forth, the subpoena return from Discord in this particular process. Some of that is probably logistical, like to authenticate the Discord through the subpoena. They need to get the records custodian from Discord, either to be here in person or to do the 1102 statement to authenticate it. And so that may be a process, but they're absolutely, well, I won't say, well, yeah, for Discord, they really probably are going to have to do that for purposes of trial. If they want to use or rely on the fact that they got the original, they were able to confirm these messages through Discord. As far as the extraction from the phone, I talked about this a little bit, but before, like a while back when we were, when the exhibit list first came out. And my suspicion why they're not going down that road is just because it potentially it gives the defense another avenue to argue that they need more time because they've had the, photographs and things like that for an extended amount of time. They got the 20 terabyte drive with all of the extractions from the devices on it. Trying to remember the timeline now. Go to the Substack. I did an article on the discovery updates. And so it's specified in there. It's either May or June, I think, but I think it was May. Might have even been April. Anyway, just, the the massive volume of discovery. They want time to go through it, need their own experts, yada, yada. It's giving them ammunition that doing it this way for the purpose of this hearing is going to avoid that. But again, at trial, almost certain we're going to see the Celebrate report, at least the portions of it that they want to show us. And again, this is important because all of this has been handed over to the defense. So we heard testimony about Celebrate extractions. We're getting no cross-examination from Mr. Davis. So no like, hey, I didn't find any of this in the extraction from Lance's phone. Hey, anything weird about it not being in Tyler's phone? It's going to be in both of them. Unless Tyler deleted it, which is going to create its own set of implications. So I think it's largely logistical, and it's because of the lower burden of proof at this hearing. But very much expect that to be a different circumstance when we get to trial. Allie B from Tennessee, timestamp exhibit showing Tyler's text. Oh, Candy, how are you going to refute this one? There are certain arenas where none of this matters. It will just, we already knew this. We already knew this. Some people are never going to care about this evidence. They will reject all of it. It's all fake. It's all fake. This is a show trial, That's fine. It is a tiny minority. It's a fringe. It doesn't matter. The majority of people who care about facts and truth will allow themselves to be guided by the evidence. Doesn't mean you have to unquestionably accept it, but it means you'll be inclined to critically engage with it and not just turn on the thought-terminating cliche. Oh, Fed slop, we're done. So you don't have to really think about it and what it means and the significance and stuff. Ellie B from Tennessee, prayers going up for Erica and Charlie's parents listening to this. So awful. Yeah, none of this is fun for them. None of this is fun for them at all. Kristen Vasquez, seems like the camera guy don't want to make any mistakes. He wants to be safe rather than sorry. I just think it's kind of the typical situation we run into a lot where the camera guy doesn't know anything about court, doesn't know what's important, doesn't know what isn't important. He knows about drama and, creating visual drama on TV. And so for him, like, oh, if I sit too long on one thing, it's boring. And so, he's trying to make it interesting visually. He doesn't appreciate what's important from a content standpoint, from a substance standpoint, what people actually care about and want to see, what matters for purposes of this legal proceeding. He cares about what it looks like. That would be my suspicion. It's not the first time we've seen this. We were constantly screaming at the camera guy in Depth v. Heard because he would do that a lot. They would have, some exhibit on the screen and he'd be panning over to look at the witness talking. And we're screaming, camera guy, you have one job, but they don't understand what that job is because their expertise is in what things look like and not what's important to capture in the frame when it comes to a legal process. Fleet Leader 1013, seems like we have a solid amount of evidence. Why would they take this to trial? Are they trying to get a deal and the state refusing death penalty versus life? That's the obvious inference. This is a hard case for the defense to win on actual innocence. Said it from day one. It's going to be hard. So, only reason to take it to trial is because you have nothing to lose. You don't have anything to lose if you go to trial and lose, if they're not willing to take the death penalty off the table if you don't. The worst thing they can do is kill you either way. So you might as well go with the option where you have even a remote chance of not getting killed. Girl Soul 11. Those texts have my spidey senses tingling. He talked about a drop spot indicating something more. Yeah, the drop point where I think this is referring to the wooded area And he was saying that he left the rifle there and he'd had his change of clothes there. And we already kind of heard yesterday from the surveillance video, the guy on camera during the morning, I think the second morning trip, went into the wooded area, had his backpack on, and then maybe didn't. Not sure if we saw him after that. I don't think we did. So yeah, it seems like he found this spot in the woods where he was going to be able to change his clothes and assemble the rifle and, yada, yada. Mary Ann Thorson. So good to see you, Mary Ann. Welcome to the channel. I know you've been around for a while, but thank you for joining as a member. I know you've been a member before. Good to see you. Love to have you here. Nope. Mopan. Sometime you don't have to super chat it, but if you would phonetically spell out your name for me, I'd love that. I'm not quite sure how to handle this one. Graphic content warning because it's just graph. Good pun. I didn't catch that one. Graphic content warning. That's pretty funny because all it was doing was just showing the judge. To Truth for Liberty. I move the court. Substitute media representative. I volunteer as tribute. No, honestly, I don't really want a legal job at this point. Taking a nice sabbatical. I can certainly get work as a lawyer as soon as I want that. But 20 years as a lawyer, the common theme, like just the characteristic of that experience is always being behind. You've always got this long ass to-do list. You got this stack of files you got to deal with. You got things that are piling up that need to be dealt with and all kinds of new things, emergencies, pulling your attention away. You never get to spend all the time that you want to get things done. So you're always like, have that question of like, well, I just had to stop. Did I do a good enough job? Is there something I miss? Is very, very stressful. And I spent almost 20 years constantly in that state. And the reason why, big part of the reason why I'm like, it's time to hit pause and maybe step away from this is I needed to remember what it's like to not have that, to not have anything that I have to do on my to-do list. 20 years with a to-do list and now I'm free and I'm still only just kind of like getting used to that. But that's also like, why my YouTube approach is the way that it is. I'd be a much better grifter if I had, like a list of things I needed to do and like kind of felt like it was a job, like it was an obligation. But that's the whole point. I don't want that. It's got to be fun. We're doing this because it's fun. I could make a lot more money off of this, if that was the goal. And I wanted to bring in that kind of stress and that kind of mentality, but I just don't think it would be helpful. I don't think it would make this better. It's fun, it's meaningful, and that's why we're doing it. Really, I see you toward the transcript. Thank you so much. Thank you so much. We're going to do it. We're going to order this transcript and see what happens, see what needs to be done. All right, guys. Thank you for kind of talking me off the ledge a little bit through your comments. I already feel a little better, a little calmer. So I'm going to go ahead and pause at this point. We do still have plenty of lunch break left. We're not coming back until 1:30 according to the court. So 40 minutes, good 40 minutes left. So I will almost certainly be back before the end of the break. But I do want to pause, go do my routine, check the animals, check the trees, maybe eat something small, whatever. But we'll pick it back up when we get back and continue to maintain a positive attitude that things will get better. Had a little hiccup this morning. Hopefully it will be learned from, not repeated. This is not a really negative trend that is going to force me to become far more critical of this really, really nice judge that I'm really inclined to like a lot. Please don't let me down, Judge. I was already crushed with disappointment with Mr. Novak's argument. What music should we have today? What did you guys think of our music the last few days? We do have a few options. A couple different options. Acoustic, cinematic, kind of xylophone. Not bad. Not bad. All right, guys. I will be back momentarily.
All right, guys, I am here. I've been here the whole time. I am actively putting a show together while watching all this. So I'm going to continue working on my show prep. I'll have this, I'll have her stream muted up. If you guys are gonna hang out here, you're gonna hear random clips, random voices, and that's because I'm putting the show together for tonight. So we've been working double duty all week long. I woke up today. I thought today was Friday. Today is Thursday. And so we're putting that all together. So thank you all for being here. We're gonna keep the stream on, and we're gonna watch as much as we possibly can. And we'll probably stop, I think, probably around like 4:30, depending on where the trial goes. 4:30, maybe 5 o'clock the latest, just so I can get a break out of the studio. And then we'll be back. We'll be back probably most likely another 2 hours. So it's been long days this week, but it's all good. It's all good. So that's what we got going on, and you'll be hearing a lot of clips in the background, guys, if you hang out. So this is supposed to be, they're supposed to be back from lunch right around 3:30 Eastern time. So that's when we'll be back.
The sound. Amazing grace. I want people to sing with me too. Amazing.
Graham Planner, you hadn't done a full scrub of who he is. How did you go about vetting him? And why did you?
We paid a nice firm a whole chunk of money and got some stuff back. Some of what you've seen on the news we got back. Other stuff we didn't.
Did the vetting process turn up the tattoo that became so controversial?
No.
Also, everyone's like freaking out about this tattoo. It's not what you think it is. It's not. It's just a Nazi tattoo.
The Reddit posts, did that turn up in the vetting process?
You go to fucking work and she almost gets hit by one. I've almost been hit. The fucking driving home. One of these dumb motherfuckers trying to pull out of here and burn out so somebody can make a video is what it is.
Oh, you're making a good video now.
I have called the cops.
Yeah, keep going.
I figured there would be people around here that would have common fucking sense.
A few moments later.
You just said that. Stupid sons of bitches.
A few moments later.
You just said that. stupid sons of bitches.
All right, what happened? Who caused it? The Infinity got out of it? Got out?
For
Oh, Trump already did.
You know you can't modify cars in California?
Wait, what? You're not allowed to modify your car, but modifying your gender gets you a parade?
Fuck Gavin Newsom!
Oh, Trump already did.
Thank God we are in California, not in third world country.
What, California? The third world countries have better power, water, and less human shit on the streets.
Because of Gavin Newsom!
People really thought a guy who fucks his best friend's wife will not fuck the whole state.
Over logic and welcome to the story of a lifetime. Winnie the Jew and Nigger 2. You see, the nigger tiger is a simple creature that values quick-hit dopamine over logic and reason. This is to no fault of the nigger tiger due to his genetic predisposition.
courtroom all week long, and she is in Provo, Utah. Chandler, what can we expect today? Are we finally going to get that video that we've been hearing for days of the romantic partner of Tyler Robinson?
We are finally going to hear it, at least.
Trace, I'll tell you right now, I'm livid about this decision. This is something.
Publish exhibit accordingly. The defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish exhibits.
I want to direct your attention to September 11th, 2025. What happened on that day in relation to your investigation?
Understand that? Okay. First, we're going to cover some of the things that we've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name, or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do. Yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023.
Here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is Bates number 58. Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
These text messages that we've been looking at. Right. You talked about the note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay. The notes have been titled 16.3 with a note on the screen.
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay, so where did you find this?
On his desk underneath his computer keyboard.
And I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
Right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah. Wishes he hadn't done it.
So he acted erratically.
He's shown Lance's phone.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time, his phone was photographed.
And you testified, I believe yesterday, that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in States Exhibit 16.1 at a picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
And you kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th, he physically, he shows them the phone and then it allows them to photograph the phone.
Reporter, when they got to the point discussing the rifle that was used, Tyler Robinson was squirming. Reporter, when they got to the point discussing the rifle that was used, Tyler Robinson was squirming, apparently uncomfortable, swinging in his chair, scratching his nose. He looked uncomfortable with the texts that were being discussed. Also, Erica Kirk was looking down, leaning forward, not looking at the screen showing those texts. Our reporter also said Erica was audibly crying throughout the proceeding today. When they got to the part about Lance was, when he was asking Tyler about the rifle and for hunting, the very graphic detail about the nature of the gun that Robinson said did well in the killing. That is when Tyler Robinson's mom started crying and wiping her eyes. Charlie Kirk's mother had her hand on Erica's upper arm and shoulder, and they were both tearful today. After showing the Discord chat logs, the prosecution also put the note from Tyler Robinson on the screen. That's the handwritten note that's been discussed that Tyler Robinson left for his lover. Our reporter inside of the courtroom says it was a very lengthy, full-page handwritten note. Trace.
Yeah, Matt Fenn, back to you as the news warrants. Thank you. Meantime, at the courthouse.
Trump's leadership. He's the first president to take this seriously. And the president wanted an all-of-government approach, which means you need someone that sort of sits above the rest of the government to really get this done. And that's why Vice President Vance's leadership is so important. And the staff
government-wide anti-fraud effort, the Labor Department's Inspector General, Anthony D'Esposito, now leading a major investigation into H-1B and perm employment visas, as well as potential human trafficking cases. Joining me now, the man leading the investigation, U.S. Department of Labor Inspector General, Anthony D'Esposito. Inspector General, great to have you. Welcome.
Great to be with you, Maria. Thanks for having me.
Well, this sounds very serious. Tell us about your investigation. Are you saying that there is fraud and human trafficking within the H-1 visa program and the program that is the Program Electronic Review Management, or PERM system?
Without a doubt. And we are going to take an aggressive action, what we believe is probably the most aggressive action against foreign labor fraud by an inspector general of this administration. We've already started to issue dozens of subpoenas. We are going to make sure that we track down every lead. We have whistleblowers talking about some of the biggest companies like Cognizant, who have been sort of, in chatter of issues with PERM and H-1B visas. And we are going to work side by side with the president and vice president's fraud task force to exhaust every lead. I'm going to take this exactly like I did when I was an NYPD detective, and I'm going to give and make sure my investigators and auditors have every resource necessary.
Ranging government-wide anti
اینو تا اینجا داشته باشین. خب بریم برای بعدیش. خیلی هم ترسناک، چشا دریده. و انقلب منقلب و من قبل قنبل بوغلمون.
Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
And that's within the home.
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. He started crying a little bit and said he wishes he hadn't done it.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. He started crying a little bit and said he wishes he hadn't done it.
Parties, we left off with Agent Davis being excused from the stand, no cross-examination, and turning to the state. Are you ready to proceed? Sergeant, if you wouldn't mind coming forward and being brought into the courtroom.
Couldn't hear, but I think it's Fau Muina. Anyway, so far, there's nothing that's been duplicative. There's no like corroboration of what we've already heard. That I think would be cumulative. But I personally don't see us being there yet. Pretty sure I'm going to go out on a limb.
Right, Sergeant, if you'd like to come forward, you're still under oath.
Yeah.
From your previous testimony from the previous day. So if you'd just like to come up to the witness stand, be seated to your left. Behind the monitor should be a bottle of water. After you're situated, if you wouldn't mind just pulling that microphone toward you to ensure that the audio is picked up. Mr. McBride, you're a witness.
Sergeant Falmuina, good afternoon.
Good afternoon.
We briefly covered some of your involvement in this case the other day. I want to return back to your initial assignment to this case. When were you first assigned to go to the campus of Utah Valley University?
On September 10th of 2025.
What time did you get that assignment?
I believe it was approximately 1:30 p.m.
And where were you when you received that assignment?
I was at a headquarters office in Salt Lake.
And did you go directly down to the campus?
Yes, I did.
And will you describe what you're seeing as you arrived there?
Yes, when I arrived there, I actually arrived near the south end of campus, and that's where I saw multiple police cars as well as multiple officers from various agencies. Then I was asked to respond to our command post, which was in the Fugal building there.
And the Fugal building, we've had some testimony about this, but is that just to the south of the courtyard?
Yes, that is.
And were you there while officers were securing campus?
Yes, I was.
And do you know generally how that was done?
I don't know the specifics, but I do know that officers were canvassing the area, trying to look for a suspect, but also trying to see if anyone else was injured, and then making sure that the scene was secure and that no unauthorized people were allowed in.
And I think you testified earlier. What was your primary assignment?
My primary assignment at the campus, as well as throughout the case, was to oversee the crime scenes as well as the physical evidence.
Before you could do your work on the crime scenes, did the campus have to become secure?
Yes, it did.
And did that involve making sure there was no active shooter on campus?
Yes.
And did that involve officers searching buildings and clearing buildings throughout campus?
Yes.
You mentioned that were there multiple areas that were processed by you and other crime scene analysts in this case?
Yes, there was. Would you like me to go over them?
Let me direct you to a few of them. Well, yes, please mention the scenes.
Yeah, so one scene was a courtyard area, or I guess what we could also refer to as the amphitheater where the event took place. The other scene would have been the Fulton Library, where there were two bus stops. And then another would have been the wooded area. And then the last one would have been the Lolosi Center, the building, as well as the ground below.
All right, let's start with the rooftop. What was who was assigned to process the rooftop area?
The team that was assigned to process that was the Utah Bureau of Forensic Services, or also known as our state crime lab.
And generally, what does processing an area involve?
Processing includes documentation, sketching, as well as taking photographs, marking, as well as labeling evidence, and then determining how to package them properly, as well as also just trying to ID anything probative.
On the rooftop was evidence found?
Yes.
What types of evidence were found on the rooftop?
One item of evidence that was found was a screwdriver. Another one would have been what we believe was the shooter's perch. That was determined that was easy to see at night. Using oblique lighting, we could see disturbances in the gravel on the rooftop. And then on the northeast edge, our team also found some swipes on the ledge of that rooftop that was also collected.
Okay, so northeast ledge. And is this the dropping off point?
Yes, it is.
You said swipes. What does that mean, swipes?
Swipes is, I would describe it as kind of hand marks or any type of marks that is left by something that causes some type of disturbance.
Okay. And where on the ledge were those located?
Those were located right on the edge of that right on the edge of that rooftop. And then right below, we also had some other swipes as well as some other impressions. And then below that was a glass window where we also located some latent prints.
Okay. I want to return to the what you've referred to as the perch, the sniper position. Were measurements taken from that sniper position to the tent where Charlie Kirk was seated?
Yes.
Do you know the distance?
Yeah. So the distance from the perch area directly to the tent where Mr. Kirk was sitting was approximately 415 feet. If you take into, and this, if you break it down, so from the perch to the tent, you're looking at is basically like this. And this is the perch and this is the tent.
And now you're describing, I'm sorry, I have to make a record. You're describing an angle, a slope downward from the perch to the location of the tent. Is that accurate?
I am.
Okay, go ahead.
Yeah, so the angle, so again, the distance, the perch to the tent was approximately 415 feet. If you think about it, or without taking into account the elevation drop, it was actually 410 feet, so just horizontal straight across. And then the elevation difference between that is approximately 68 feet.
Okay, 410 feet from the perch to the tent, with a 68-foot vertical drop. Is that right? On the rooftop, were shoe impressions found on the rooftop?
Yes, there was.
Did those who processed that area of the crime scene collect the latent prints and the shoe impressions that you've talked about?
Yes, they did.
This is a good point to read a stipulation into the record.
All right.
The language of this has been agreed upon by the parties. The parties stipulate that investigators at the crime scene observed latent fingerprints and a palm print on a glass window near the area where the individual landed when the individual jumped from the rooftop of the Low-C Center at UVU. SBI fingerprint examiner Elisa Farmer examined images of these latent fingerprints and the palm print and determined that only 3 of the latent prints, 11B, 11C, and 11D, were of comparable or of poor comparable value. She excluded Tyler Robinson as the source of any of these 3 latent prints. Ms. Farmer reviewed other prints on the window and found that they did not have adequate value for comparison. Subsequent examinations of these 3 latent or actual latent prints by the FBI were inconclusive. That area that was described in that stipulation, is that the area in the glass window that you're talking about?
Yes, that is.
That's on the northeast corner of the Low-C Center?
Yes.
And that's the area where we see in a video an individual drop from the roof?
Yes.
I want to move on to another area, the courtyard. First, will you describe what that area of the crime scene looked like?
Yeah, so when I arrived on scene, you have different steps. I believe there were maybe like five or six covered in grass. When I was there, there were personal belongings spread throughout. There was a tent towards the west end of that courtyard area, as well as some banners and some barriers as well.
Was that area processed for evidence as well?
Yes, it was.
What was done to process that area?
Photography, as well as just examining the tent area to see if there's anything there.
And who is assigned to process the courtyard area?
The FBI.
I want to take you to another area, a wooded area. Was there a wooded area that was processed as well?
Yes, there was.
Will you describe, first off, where that area is?
Yes, so this area is located northeast of the Low-C Center building, and it is across from Campus Drive.
Your Honor, can we publish Exhibit 35, please?
Yes.
Do we Do we know what Exhibit 35 is? I thought I've been waiting to find out.
If I may approach the witness, I'll put up the hard copy of this exhibit as well.
All right.
Oh, it's just the, okay. It's the tag board thing.
Can we publish oh, thank you. All right, on the screen in front of you, will you take a look at Exhibit 35?
Yes.
Do you recognize that?
Yes, I do.
Will you take a moment to orient yourself on that map and tell me when you've found the relevant points that help you understand what this map is of?
Yes.
Do you see the courtyard on that map?
Yes, I do.
Kimberly, can you zoom in to the courtyard area of kind of the center of the, there's a pointer on the screen. Is that the courtyard?
Yes, that is.
All right, now the low C center, will you describe, well, let's jump to the wooded area. Where is the wooded area that you're talking about seeing that was processed?
Yep, the wooded area, if you go from the courtyard and you go northeast, you're going to come across this big parking lot. And then if you just go directly north to that.
Okay, this is, at this point, it might be easiest for you to actually indicate on the physical map. If you don't mind just standing up, is
Camera guy.
give you a handheld mic here.
Thank you.
Yes, so the wooded area is approximately right here in this area.
Okay, so just to make a record of the area, on the northern, I guess I'll say, and north is up on this map, is that right?
Yes.
Do you know where Campus Drive is?
Yes, Campus Drive is this road that winds right along here.
Okay, and so that's kind of the windy road that begins the upper left-hand corner of the exhibit and winds down through the center of the map and kind of exits to the middle right side of the map. Is that right?
Yes.
And the wooded area, where is it in relation to the Campus Drive?
It is north of Campus Drive.
Okay, kind of in that, probably the center right of the map. Is that right?
Yes, that's correct.
Will you describe, first off, what is on the south side across the street from the wooded area?
Yeah, so on the south side of the south side of the wooded area, we have the computer science building, which is to, I guess, east. And then we have a parking structure, and we have a walkway along here in between that connects the computer science building and the Losi Center building. And then right onto the southwest of the parking lot area is going to be the Losi Center building.
Okay. Now you referred to the area across the street from the wooded area as a parking structure. That's a parking lot, right?
I'm sorry.
And there is a parking structure on campus, correct?
Yes, there is.
But that's different than the parking lot you just mentioned.
Yes.
Okay. All right. Back to the wooded area. What was found? Was anything found in the wooded area of evidentiary value? You can sit down. Thank you. You can take that.
May you repeat your question?
Was anything of evidentiary value found in the wooded area?
Yes, in the wooded area, a rifle that was wrapped in a dark colored towel was found there.
And how did you learn about that?
I found that out because just a little bit before 6 p.m. that day, I received a call from Utah County Sheriff's Office, who was tasked with searching that area.
Do you know why they searched that area in the first place?
Yeah, so they searched that area because I received a video that was from the UVU security footage. This was received by our command post on scene, and it showed who we believe was the shooter on the rooftop run from the southwest corner all the way to the northeast corner, jump down, and then continue to the northeast side of that campus, and then cross the street to Campus Drive. And then the suspect was out of camera's view after that.
Okay, so he ran basically toward and into that wooded area.
Yes.
Right. What were you told from the sheriff's office?
I was told that they found a gun, and from there I asked them to hold the scene, and that myself and FBI ERT team, the lead, Special Agent Kamak, would be en route.
Okay. FBI ERT, FBI Evidence Response Team, right?
Yes.
All right. Did you go to that area?
Yes, I did.
Did you observe the weapon?
Yes.
Will you describe what you saw?
Yeah, what I saw was a rifle that was, or at the time before even having removed it, we found, or in the bushes, we found all you could really see was just a dark towel there. So pictures were taken of that, and then eventually the gun or the towel was removed. And then once we removed the towel from the bushes is when we uncovered that the towel was actually used to wrap the gun in.
Have you reviewed State's Exhibits 10, 10.1, 10.2, and 10.3? Do you remember reviewing these?
Yes.
And are they accurate photographs of the weapon when it was recovered and shortly thereafter?
Yes.
I move the admission of State's Exhibits 10, 10.1, 10.2, and 10.3.
And publish?
No additional objections.
All right. And as it relates to publication, if any?
Yes, I would ask that these be published at all three levels.
All right. Any input, Mr. Burt?
Same objections.
All right. I'll note the standing objections from defense. Those are overruled. And 10.1, 10.2, 10.3 are admitted into evidence and may be published both in the courtroom and through the use of the camera.
If we can please publish number 10. Thank you. You have in front of you on the screen Plaintiff's Exhibit 10. Will you describe what we're looking at here?
Yes, what we are looking at here is actually the bushes where the dark colored towel and the gun were found. You can kind of see the dark colored towel towards the right-hand side of the screen in the middle, right middle.
Kimberly, can you zoom into that area, please? All right, is this a better view of the towel?
Yes, it is.
Kinda. You say so.
Exhibit 10.1. Will you describe what we're looking at in Exhibit 10.1?
Yes, this is a mid-range shot of, again, the towel that was used, or of the towel and within the bushes.
All right. When this was found and you arrived on scene, what happened with that weapon?
We moved it from the bushes, or say FBI Special Agent Kamak removed it from the bushes. We then placed it on a cardboard box, took pictures of it, and then we removed the towel, packaged the towel separately, took additional pictures of the gun, and then rendered it safe on scene.
Okay, I'll ask you about that more in a minute, but let's go to number 10.2. Will you describe what we see here?
Yeah, so what you see here now is a dark colored towel and the rifle that is in the towel, and it is in a cardboard box.
Why is the towel still around the gun?
We wanted to document as to how it was found.
All right, let's go to 10.3. Is this the rifle?
Yes, it is.
You described making the rifle safe. Will you describe what that is?
Yeah, so what that is that we ensure that there isn't anything in the chamber and that there's no other cartridges in the gun that would have it go off. So to do that, because it is a bolt action gun, we would have to manipulate the bolt or the lever back, and then from there see if anything was in the chamber, and then let's say carefully remove anything that was in the chamber and below it.
All right. What is the difference between a bolt action and an auto ejecting gun?
Yep. A bolt action is one where the user actually has to manipulate the bolt. So they would actually have to turn, or they would actually have to pull it back and forward to, whether it be to load it, lock it, as well as extract anything that's in it. Unlike a semi-auto gun, that is one, every single time you pull the trigger, a bullet will be fired, and then from there, a casing will be extracted out, as well as a new cartridge will then be automatically fed into the chamber.
So if you shoot a bolt action rifle, does that spent shell casing automatically exit the gun?
No, it does not. It will stay in there until the person that is handling the gun actually removes the bolt, or actually pulls the bolt back, and then the casing will be extracted out.
Were you present when this weapon was made safe?
Yes, I was.
Will you describe what was found when that happened?
Yep. So when we rendered the gun safe, we found in it, when we removed the bolt back, we found one 30-06 cartridge case, or I should say a fired cartridge case, and we also found 3 unfired cartridges, all with engravings on them.
Okay. I want to make sure we understand the language you're using. When you say cartridge case and you say cartridge, what do you mean?
Yep. So a cartridge is basically the round itself, right? The whole round. And the round consists of the cartridge case, and then the powder, and then the bullet on top. So the cartridge case, the term is used for something that has been fired already. A cartridge is an unfired round.
Okay. Cartridge is the unfired round that still has the bullet, the powder, and all that.
Yes.
Cartridge case is the fired, is a round that has been fired, and it's just the empty brass casing. Is that right?
Yes.
Okay. Was there any, so there was, I just want to make sure I understand, a fired cartridge case and 3 unfired cartridges.
Yes.
Was there anything distinctive about these items?
All 4 of them had engravings on them.
Did you observe those engravings?
Yes, I did.
Did you observe them right there on scene?
Yes, I did.
And what was done with, let's talk about each of those things. First, the towel. What was done with the towel?
The towel was packaged and then it was eventually provided to the FBI.
What was done with the firearm?
The firearm was also packaged and then provided to the FBI as well.
Did the firearm go to the FBI or the ATF?
Oh, sorry, correction. It went to the FBI, and then to be in their custody, and then it was then sent to the ATF lab.
Okay. And the rounds, the cartridge and cartridge cases, yep. The cartridges and cartridge case.
Yes. All those were packaged, originally provided to the FBI, then was sent to the ATF lab.
Right. And were each of those items tested?
Yes, they were.
And in the testing, were they photographed?
Yes. Yes.
Well,
Have
I
you
think
reviewed
because
and were they photographed by the ATF when they were tested?
Yes, they were.
Have you reviewed their photographs?
Because he didn't plan to lose the gun.
Yes.
And were you previously shown states exhibits 19, 20, 21, and 22?
Yes.
And are those photographs that the ATF or that you received back from the ATF of those cartridges and the cartridge case?
Yes.
Did they have the same appearance and etchings that you saw when you observed them removed from the gun?
Yes.
And did those photographs accurately capture those etchings?
Yes.
I move to admit states exhibits 19 through 22.
Mr. Burton.
Additional objections.
All right, I'll note the standing objections. Those objections overruled, and 19, 20, 21, and 22 are admitted. Now,
what,
to
if
publication,
anything?
Mr. McBride.
I would move to publish these exhibits at all 3 levels.
All right, any further objection from?
No further objections.
Thank you. Again, I note the standing objections as are overruled. They may be published both in the courtroom and captured by the media camera.
Let us start with exhibit 19, please. What are we looking at here in exhibit 19?
This is the cartridge case that was recovered from the gun.
And what position was this in the gun?
This was this is what was in the chamber.
Okay. In the chamber, meaning that's where a cartridge is before or when it is fired, correct?
Yes.
Do you notice an inscription or an etching on this cartridge case?
Yes, I do.
Will you read what that says?
Yes. Notice this bulge.
And if we can go down to page 2 of the exhibit, will you read what this says?
OWO, what's?
And to page 3?
This.
And question mark, correct?
Yes, question mark.
All right, if we go to State's Exhibit 20. Is this a photograph of one of the cartridges that was found in the gun?
Yes, it is.
And what are we looking at here in this view of page 1 on Exhibit 20?
This is the head stamp of it, and it says it is according to the head stamp, it is a Remington 30-06 Springfield.
Is that a different caliber than a .223 round?
Yes, it is.
Will you look at page 2 of Exhibit 20? Will you read the markings here?
A fascist.
And page 3.
Catch.
And page 4.
Up arrow, right arrow, down arrow, down arrow, down arrow.
All right, let's go to Exhibit 21.
Our gun people are already going to know like exactly what type of ammo this is. So normal copper
And was this
bullet.
another round that was found in the gun?
Yes.
Will you read the inscription here?
Oh, Bella Chow.
Page 2.
Chow, chow.
All right, let's go to Exhibit 22. Another round that was found from the gun, correct?
Yes.
Will you please read the letters here?
If you read.
Page 2.
This comma, your, or correction, this comma, you are.
Page 3.
Yay.
And page 4.
LMAO.
Bella Ciao.
All right, after processing the scenes there at Utah Valley University in Orem, did you go to St. George?
Yes, I did.
And what was your role in St. George?
My role was overseeing the execution of the search warrants at both Mr. Robinson's residence as well as his parents' residence.
And we've had testimony that Mr. Robinson was arrested there. Was he fingerprinted and his DNA taken?
They were actually taken at the Utah County Sheriff's Office jail.
After he was transported to Utah County? Okay, you said that there was, were items of evidence collected from him after he was arrested?
Yes, there was.
From his person. What were those things?
They were his clothing that he was wearing at the time of his arrest, to include shirts, pants, underwear, as well as shoes and anything that were in his pockets.
Do you remember what tops he had on?
I believe it was a maroon top.
And was there any other top layer that was collected that you recall?
I don't recall.
Okay. Let's go to, you said there were a couple of homes that were searched there, is that right?
Yes.
Whose homes was that?
One of them was where Mr. Robinson and Mr. Twiggs resided, and the other was Robinson's parents' residence.
I want to ask you about the defendant's home. What items will you describe some of the items that were collected from that home?
Yep. Some items collected in that home were a Dremel tool and its bits container, as well as two Remington boxes of 30-06 ammunition, as well as some 30-06 cartridge cases, and a handful of long guns or rifles, a revolver, as well as a burned paper.
All right. I want to ask you about clothing as well. Was any clothing collected from the townhome?
Yes, there was.
How about shoes?
Yes.
What kind of shoes?
Two shoes were collected from the home. One was a Converse shoes, gray in color with white laces, I believe a size 10.5. And then another Converse shoes that were also gray, but had gray laces instead, but were of a different size that I can't remember.
I think you said that you collected boxes of ammunition. Do you remember what caliber that ammunition was?
Yes, there are a handful, but the one that I recall was 30-06.
And you also said you found some cartridge cases. Do you remember what caliber those cartridge cases were?
Yes, those were also 30-06.
If we can display just to the witness Exhibit 23. Do you recognize Plaintiff's Exhibit 23?
Yes, I do.
And is that an accurate photograph of the cartridge casings and some of the bullets you found?
Yes.
I would move the admission of Plaintiff's Exhibit 23. Mr. Burke?
No further objections.
I'll note the standing objections by defense. Overrule those objections and admit into evidence State's Exhibit 23 as to publication, Mr. McBride.
I would move to publish at all three levels.
All right. It is published to the courtroom as well as maybe broadcast via the camera.
As that's coming up, where did you find these?
I found these in what we would consider the spare bedroom, right next to Tyler's bedroom, on top of a safe.
How do you know which bedroom is Tyler's bedroom?
We determined that based off of some documents we found in what we believe was Tyler's bedroom, such as mail that was addressed to him, as well as some school documents as well.
And again, in relation to, will you describe the layout of the house in that area?
Yep, so the house was on the second floor. As you're coming up the stairs, if you turn the left up the stairs, you're going to run into two bedrooms, and that is on the south end of that residence. The southeast bedroom would be Tyler's, and then the southwest would be the spare bedroom. Again, if you go back to the stairs and you make a right-hand turn, that is where you're now on the north end of that residence, and that is now Twig's bedroom.
And where were these items here in 23 found?
These were found on the southwest, or in the southwest bedroom, the one right next to Tyler's bedroom.
And you said on top of a safe?
Yes.
Okay. All right. Will you describe what we're looking at in Exhibit 23?
Exhibit 23 are the 5 cartridge casings we found on top of the safe. All were 30-06 Springfield caliber, and one of them had an engraving that said "test shot" on it.
You've talked about Springfield, Remington. Are these 30-06s? Are they the same type of round as was found in the gun?
Yes. Yes.
All right. Did you find any 30-06 weapons in that house?
No, we did not.
Oops.
All right. Did you search the closet on the first floor?
Yes, I did.
What did you find in the closet?
In the closet, we found on the ground some shooting targets with perforations in it, as well as on the shelf, we found a Dremel tool with bits container.
All right, a Dremel tool with bits. What is a Dremel tool?
It's basically like a handheld device where you can make etchings or engravings on things.
What are bits?
Bits would be I guess like a sharp edge or something that would actually cause the etchings that you would put into the tool.
Is this kind of like a drill bit?
Yes.
And what did you do with the Dremel and the bits?
We photographed them in place, took additional pictures, packaged them, then sent them for testing to the ATF.
All right. You also mentioned targets. Were those targets photographed?
Yes, they were.
I want to show you on your end. Have you reviewed Plaintiff's Exhibit 25 before?
Yes.
And is that an accurate photograph of those targets that you found?
Yes.
I move the admission of State's Exhibit 25.
Mr. Burt?
No further objections.
All right, and note the standing objection, and those objections are overruled.
Excuse me, sorry.
Oh, well, did you want to, in regards to publication?
Yes, I'm so used to admission before publishing. I would move to publish those at all 3 levels.
All right. Any further comment, Mr. Burt?
No further objections.
Again, all right, noting the standing objections, those are overruled. State's Exhibit 25 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
Will you describe what we're looking at here?
Yeah, so these were shooting targets we found in the closet, and each of them have perforations in them.
Camera guy, did you fall asleep?
What do you mean?
Holes in them.
Those holes consistent with?
Objection. Foundation on this opinion.
Mr. McBride,
So
do
he
you want
pulls
to
to the
weigh in
left
on that objection?
and slightly up. But then he adjusted down
I'll
to
submit
the
it all the way
right.
to foundation if the objection is sustained.
I'll sustain the objection.
All right. Holes. Have you ever shot a gun before?
Yes, I have.
When you hit a target, what happens to the target when it's hit with a bullet?
Hit with a bullet, there's holes in it, what we call perforations, because there's a entrance as well as an exit.
Looking at State's Exhibit 25, I'm going to ask the question that was objected to. You said there's perforations in those. Are those consistent with bullet holes?
Yes.
And I would ask you to describe where those perforations are there's 3 targets here, right?
Yes.
Let's look at the
Sergeant, do you know how to sight in a rifle?
Where are the perforations in relation to the bullseye?
They're all probably within the 7, 6, and 8 ring.
Is there a perforation up at the upper left-hand corner of that rightmost target?
Yes, there is.
Did any of those hit the bullseye?
No.
Okay, looking at the center target, will you describe where the perforations are in relation to the bullseye there?
It is closer, but still not it. Most of them are to the left of the bullseye in rings, I'd say 9 and 8.
All right, and then the leftmost target, will you describe where the perforations are there?
Yeah, the perforations are actually closer to the bullseye as well, actually one being in it.
All right, you described also collecting a burnt note. We can take down 25. Thank you. Will you describe where that note was found and what it looked like to you?
Yeah. The burnt note was found in the trash can located in the kitchen. The way it looked like to me, it looked like, say you're at like a campfire and someone burns paper.
What was done with that?
That was also collected and that was sent to the FBI for analysis.
Was it photographed?
Yes, it was.
And have you reviewed State's Exhibit 24?
Yes.
Is that a photograph of the note?
Yes.
I move the admission of Plaintiff's Exhibit 24.
Mr. Burt?
No further objections.
All right, and to publication?
I move to publish at all 3 levels.
All right, I'm going to note the standing objection by defense and overrule those objections. And State's Exhibit 24 is admitted into evidence and may be published in the courtroom and may be captured by the media camera.
Do you see here on the screen Plaintiff's Exhibit 24?
Yes, I do.
It looks like as to the evidence tag, it's actually upside down. Is that right?
Yes.
Does it look like there's any writings on that note, on that burnt paper?
Yes.
Will you point that out for the judge where the writing is?
Yep.
and describe what you're pointing at, kind of the general location on the
Now it is.
Yeah. So the part that I'm pointing out is the paper that you can still see the lines in them, and as well as some handwriting as well to the edge, the left edge of that piece of paper.
All right. Have you also observed the image of a note that was recovered from last Twig's phone?
Yes.
And I'd like to show you here in exhibit side by side, exhibit 24.
Ooh, thank you for showing us that.
And there on the left, you see exhibit, well, that's good. There on the left, we see exhibit 24. Do you see that?
Yes, I do.
And on the right, you see, excuse me, on the right is 24. On the left, it's 16.
This is the cartridge.
I'm not sure. Is this being broadcast?
Let's
It's not,
take that
Judge. He fixed it.
All right.
Exhibit 24. Thank you, Your Honor. Excuse me, exhibit 16.3. I would move to publish exhibit 16.3 and 24 side by side. I think they're currently on the council monitors.
So 16.3 has already been admitted.
And I don't remember the court's order if this was to be captured by electronic media or not.
It was not. Okay. Does that comport with defense's memory as well?
It does.
All right. So 16.3 was published to the courtroom, but not to be captured by the media. So as it's, and what is your request?
To comply with court's order.
All right. So 16.3 and exhibit 24 may be published side by side only to the courtroom itself and not on to be captured by the camera.
Why is our audio off? Oh my good Lord. More of this. I don't know that it was really the camera guy that messed it up. I think it was the prosecution that put it up on the big monitor, because if it wasn't, although I guess if they let it go to the courtroom but not to us, then yeah, I guess it's the camera guy. I don't know. It's inadvertent. Nobody was deliberately doing it, but that was a little oops. More for our secret transcript. I agree, it's been captured. It was there long enough. Yep, I agree. This is really stupid. They can hear it in court. I don't know why we're not hearing it. Except we can't see the lawyers. That looked pretty eye-rolly from the judge, but hard to say.
Acknowledging that the magistrate can weigh the evidence and is not weighing in on this evidence, solely admitting it. Well, it's already been admitted, but as it relates to the testimony, the court is going to overrule the objection and allow the testimony to be given. Again, whether the court accepts or doesn't accept that will be a determination made when determining probable cause.
Thank you. You see any consistencies that you're...
We don't get to hear the testimony either. It's getting wild. Getting a little off the hook, Judge. So the reason why the hollow point matters, if that's what it is, much more, I mean, its job is to mushroom and fragment. It's what it's made to do. I don't either, girl. I don't either. I'm lost about why are we different from the audience?
Did you also collect the defendant's car?
Yes.
Where did you collect that from?
That was collected at the Robinson's parents' home.
And will you describe that vehicle?
Yep, that vehicle is a gray colored Dodge Challenger.
What year? Stock? Modded? Anything else?
All right. You've mentioned that you sent several items to the ATF and the FBI for testing. And did you receive reports back from both of those entities with results of their testing?
Yes, I did.
I'd like to show you on the witnesses screen only right now, or counsel's screens, Exhibit 30.
All right, while you're doing that, Mr. McBride, and also, could we go ahead and take down State's Exhibit 35? I know it's just in the background, but just to be consistent on displaying of exhibits. All right, thank you. You may proceed.
Plaintiff's Exhibit 30. Do you know what this is?
Yes, this is the ATF report that I received regarding the DNA testing on the gun and cartridge casings. Or sorry, correction, cartridge case and cartridges.
Thank you. And is this in the same condition as it was when you received it?
Yes.
Your Honor, I'd move the admission of Exhibit 30.
No further objections, Your Honor.
All right, I note the standing objections, and as to publication, Mr. McBride.
Yes, Your Honor. This exhibit deals with DNA testing on the rifle and the cartridges. We would move to have it published at all three levels.
All right, so noting the standing objection by defense, I'm going to overrule that objection pursuant to Utah Rule of Evidence 1102. State's exhibits, and this is 30?
30.
State's Exhibit 30 is admitted into evidence and may be published on screen in the courtroom and for the media camera.
I want to ask you a little bit about the format because it may be helpful to understand here, but on page 1 under the exhibits, we have here a list of items that were sent in for testing and comparison. Is that right?
Yes.
And throughout the report refers to the items compared by the lab number. Is that right?
Yes.
So if we can scroll down just to the bottom of this first page, and here in the DNA analysis section, again, we see that the report or the author refers to the items by their exhibits numbers, right?
Yes.
Okay. And if we can go to page 2. And same question here. The exhibit number on the left, if we want to know what exhibit number that is, we have to refer back to page 1 for the description, right?
Yes.
Okay. And let's keep going to page 3. If we can just scroll through page 3, 4, and land on page 5. Actually, pause right there, if you will. This is page 4. There's a description section here as well. And that description talks about where the swabbing that's used to compare what was swabbed for the comparison. Is that right?
Yes.
Okay, let's go to page 5. So as we look at this first paragraph here under statistical analysis, let's see if you have this notated or no. Exhibits 1.1 and 1.4. Do you know what that is referring to?
Yeah, they're referring to 1.1 is swabs of the stock and grips of the rifle, and then 1.4 is swabs of the bolt of the rifle with possible ridge detail and or smudging.
Okay. Will you read paragraph D?
Yes. The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson, Exhibit 7.1, as a contributor to the major components and 3 unrelated unknown individuals than if they originated from 4 unrelated unknown individuals.
And again, that's swabs of the grips and the bolt. Stock and grips and bolt, is that right?
Yes.
Okay. Number 2, calculation number 2. Where is this swab taken from?
Exhibit 1.2 would be swabs of the butt plate of the rifle.
And will you read paragraph D here?
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 4 unrelated unknown individuals than if it originated from 5 unrelated unknown individuals.
Looking at calculation number 3, exhibit 1.3, what areas were swabbed for this comparison?
1.3 is swabs of the trigger and trigger guard of the rifle with possible ridge detail and or smudging.
Will you read paragraph D?
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
If we can go to page 6. Calculation number 4, exhibits 1.5 and 5.1. What are those?
1.5 are swabs of the forend of the rifle, and 5.1 is swabs of 1 30-06 cartridge.
And again, that cartridge came from where?
From the firearm.
Will you read paragraph D?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
All right, let's look at calculation number 5, 1.6 and 3.1. What are those?
1.6 is swabs of the barrel of the rifle with possible ridge detail and or smudging, and 3.1 is swabs of 1 30-06 cartridge.
And that 30-06 cartridge came from where?
From the firearm.
We read paragraph D.
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as a contributor to the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
Okay, statistical analysis calculation number 6, exhibit 1.9. Where is that from?
1.9 is the swabs of possible ridge detail and or smudging on the optical accessory of the rifle.
Is that a scope?
Yes.
Okay. Will you read paragraph D?
The DNA profile is 6.28 billion times more likely if it originated from Tyler Robinson as a contributor to the major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
Okay. On number 7, I'm not going to read that. I think we've gone through this enough. That's the last one in this report. Is that correct?
Yes. Yes.
All right. We can go to exhibit 32. 31 was previously received. And just display this on the screen of the witness, please.
Lots of mixtures. Interesting. Interesting.
I think it might display on the gallery video. Okay.
These aren't population statistics, though.
All right, thank you. Can you see Exhibit 32 on your screen, Agent Feldman?
Yes.
We'll talk about this again.
This is an ATF report that I received in relation to the gun as well as cartridge case and cartridges.
And is this report in the same condition as it was when you received it?
Yes.
I move the admission of State's Exhibit 32.
So question for you, was this the report that was previously disclosed in one of the early motions?
Yes.
All right. All right. To Mr. Burtz.
No further objection, Charlotte.
All right. And for publication level?
All 3 levels.
All right. As it relates to State's Exhibit 32, is accepted into evidence.
It's like you know me.
Published in the gallery as well as electronic. The media camera can capture it. And I note that this has been previously disclosed publicly from an earlier filing, I believe from either late last year or early this year. So for those
January
reasons,
9th, I believe.
it's accepted into evidence and may be published at all levels.
Your Honor, it's 2:30. I probably have 10 more minutes. Would you like to take a recess now or after I finish?
Let's just do the 10 minutes.
Okay. All right. Exhibit 32 is in front of you. And what was being analyzed in this test?
What was being analyzed would have been the cartridge case as well as the bullet fragment and the lead fragments that were recovered from Mr. Kirk at autopsy.
All right. Same question on structure of the exhibit. The lab numbers and agency numbers are listed here on the first page, right?
Yes.
And if you want to know what the report is talking about, you have to refer back to there, right?
Yes.
All right. I want to have you read, if you can scroll down to the bottom of page 1. Thank you. I would ask you to read the second line under results of examination.
Yes. The Exhibit 1 rifle was test fired and found to be in operable condition. The test fires were designated as Exhibit 1.11.
And again, Exhibit 1 rifle is what?
Is the one that we found on campus.
Okay. Exhibit 2, if you'll look at the next, skip the next line and then go to the Exhibit 2 cartridge case, will you read that sentence?
Yes. The Exhibit 2 cartridge case was identified as having been fired in the Exhibit 1 rifle.
Okay, now I want to jump back up to the top where it lists the exhibits. 2 through 5, will you explain what those are and where they came from?
Yes. That would be the items we found in the gun on scene. And this was the gun that was found in the wooded area.
And so the cartridge case is the round that had been, is the case that had been fired.
Yes.
Okay, so that's number 2. All right. I can't remember. Did we already read that line? Exhibit 2 cartridge case?
Yes.
Yes.
Okay, thank you. Will you also look at or read the last paragraph on this page?
Yes. The Exhibit 2 cartridge case and Exhibit 3 through 5 cartridges were examined for the presence of comparable tool marks. Tool marks were located on the exterior of the Exhibit 2 cartridge case and Exhibit 3 cartridges, in parentheses, scribe marks, that are consistent with being produced by engravings and or rotary cutting tips commonly found.
And scroll down, please, Kimberly.
Installed in handheld rotary tools, such as a Dremel tool. These tool marks contain marks of value for comparison if a suspect tool is located.
Okay, I'd ask to scroll back up to show the exhibit list. Number 6, what is Exhibit 6?
Exhibit 6 is the bullet fragment, the bullet jacket fragment, as well as some other fragments that were recovered from Mr. Kirk at the time of autopsy.
Thank you. Going back to page 2, will you read the first full paragraph there, beginning with Exhibit 6?
Yes. Exhibit 6 consists of one .30 caliber class deformed damage bullet jacket fragment and 4 lead fragments.
Will you read the next paragraph as well?
The Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1 rifle based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The results of the comparison was inconclusive.
And if you'll look at the line starting with the Exhibit 6B through 6E, will you read that sentence as well?
The Exhibit 6B through 6E lead fragments are not suitable for microscopic comparison.
Thank you. We can take Exhibit 32 down.
Not when the bullet's jacketed.
Exhibit 33, if we can show that just to the witness, please. Do you recognize Exhibit 33?
Yes.
What is that?
This is an ATF biology report on the Dremel tool as well as the cartridge cases that were found on top of the safe in Tyler's home.
Did you receive this from the ATF in response to your request for testing?
Yes, I did.
I move the admission of State's Exhibit 33.
No further objections, Your Honor.
Thank you, Mr. Burtz. Noting the standing objections by defense and level of publication, Mr. McBride.
All three levels.
Court overrules the standing objections and State's Exhibit 33 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
Judge, you're back on my good side.
What was being tested here?
The Dremel tool, the bits container, as well as the cartridges and cartridge casings we found in Tyler's home.
And up in the top right, it says forensic biology. Is this DNA testing?
Yes, it is.
Okay, format of this is the same as the other report that we already looked at, right?
Yes.
Let's jump to page 4. Calculation number 1. It mentions here Exhibit 15.1. Do you know where that swab is from?
Yep, it is swabs of the buttons of the Dremel tool.
And will you read paragraph D?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a contributor to the major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
We also read paragraph E.
The probability of an unrelated individual in the population who has not contributed DNA to this sample yielding this level of support is less than 1 in 1 trillion.
Thank you. I'm not going to ask you to read those paragraphs for the rest of the statistical calculations, but I will ask you to go through and identify where the swabbing came from. Exhibit 15.3, which is calculation number 2, where's that swab from?
As swabs of the cord of the Dremel tool.
Exhibit 15.5.
That would be swabs of the longest metal bit of the tool.
Going on to page 5. Calculation number 4, exhibit 15.6.
15.6 is swabs of the shortest metal bit.
And calculation number 5, 18.1.
This is swabs of 1 etched 30-06 cartridge case.
What is that? Where did that come from?
That come from on top of the safe.
Okay. Is that the one that had the etching test shot?
Yes.
Test shot.
Will you read the paragraph D as it relates to the test shot swab?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
Thank you. We can take Exhibit 33 down.
Definitely lots of mixes.
The final report is 34, if we can publish that just to the witness. What is State's Exhibit 34?
This is an ATF report I received that was comparing tool marks.
And is this, I move the admission of Plaintiff's Exhibit 34 and publication at all 3 levels.
Mr. Burt.
No further objections.
All right. And all right, so State's Exhibit 34 is admitted. The objections, the standing objections by defense are overruled. They may be published in the courtroom and captured by the media camera.
Okay, looking at the exhibits, might have to go back and forth here, but let's go to page 2. And will you read the paragraph that starts with Exhibit 18 consists?
Yes. Exhibit 18 consists of 5 30-06 Springfield caliber fired cartridge cases, designated Exhibits 18A through 18E, and 15 45 auto caliber unfired cartridges, designated Exhibits 18F through 18T.
Okay. 18A, do you know what 18A is?
Yes, this would have been the 30-06 cartridge case with the engravings test shot on it.
Okay. Will you read the paragraph beginning with the Exhibit 18A?
The Exhibit 18A cartridge case was examined for the presence of comparable tool marks. Numerous sets of tool marks were located on the exterior of the Exhibit 18A cartridge case that are consistent with being produced by engravings and or rotary cutting tips commonly found installed in handheld rotary tools such as a Dremel tool. These tool marks contain marks of value for comparison.
Okay. The next paragraph I asked you to read is the one that starts with Exhibit 16. But first I want to ask you, do you know what Exhibit 16 is?
Remind me off the top of my head.
Okay. 18, it also says Exhibit 18A through 18E. Do you know what those are?
18A through 18E would be the cartridge cases that were found on top of the safe.
Okay. If you'll read paragraph, or that paragraph.
Which one again? Sorry.
The one starting in Exhibit 16 and.
Yes, the Exhibit 16 and Exhibit 18A through 18E cartridge cases were identified as having been fired in the Exhibit 1 rifle.
Okay, let's now jump to the paragraph beginning the test tool marks. Kimberly, if we could scroll down. Will you please, well, first off, 15A and 15B, do you know what those are?
Yes, those would be the longest metal bit and then the shortest metal bit.
Okay. If you would read, okay, and then also Exhibits 2, the Exhibit 2 cartridge case, what is that?
What's the one from inside the gun?
This would have been the cartridge case that was found in the gun.
And Exhibits 3, 4, and 5 cartridges?
They were the ones also found in the gun.
And Exhibit 18A?
Is the one that was found on the safe.
Okay. If you'll read the first bullet point there, the Exhibit 15A.
Yes. The Exhibit 15A engraving cutter was identified as having made tool marks located on the Exhibit 2 cartridge case, Exhibit 3 through 5 cartridges, and Exhibit 18A cartridge case.
And will you... Okay. We can go ahead and take that down.
Oh, Cartridge voodoo. We'll talk about it. Who are these people in the jury box? Are they just random audience people, court people? I don't know.
Your Honor, I want to, before I ask to enter my final line of questioning, I'd like to show the witness exhibit 12.1. And this is the video, the UVU surveillance video. Let's see, I think it's 12.4 was the surveillance video actually that was approved for publication.
That's correct. That's the unmarked, non-zoomed version, correct?
Got it.
Yes.
Thank you for the clarification.
Yes.
And just for now, let's do this on the witness's screen.
Oops.
.4, and I'll ask you to jump to the 804 mark. Okay. I'd move to publish. We intend to play about 10 seconds of this video. I'd move to publish that at all 3 levels.
Mr. Burt.
I'm not sure what the relevance is at this point, so it's hard to object or not. I would ask for a proffer as to what it's shown because it's not apparent from the exhibit.
Understood. Proffer is, there's been testimony about prints being found on the glass window of this building. This exhibit demonstrates the suspect's behavior in that area.
All right. Anything further?
With that, I don't have any further objections.
All right. So it may be published. This is already admitted, and it may be published at all levels.
Thank you, Judge.
Okay, before you pause, before you hit play here, Sergeant Falmuina, do you see what's on the screen in front of you?
Yes, I do.
Can you see the suspect in this image?
Yes.
Will you describe where that suspect is?
He's on the rooftop, let's say on the gravel part, and this would have been close to the northeast side of that building.
Timestamp is 12:23:47 p.m. Is that right?
Yes.
And that portion of the image that we see there, the video, is the top portion of the image slightly to the left of center. Is that right?
Yes.
Okay, we're at 8:01. Kimberly, will you please hit play there?
Don't get eye strain, everyone. We don't need our migraines.
Let's go ahead and pause it. Pausing it at 8:20. Were you able to determine if the suspect touched the glass when he dropped from the roof?
Not at the time when we first saw the video, no.
Okay. Were you later able to make any determination on that?
Yes, because the video we had was pretty grainy at the time on at the command post, and it wasn't until we're actually able to get the footage directly from UVU.
And when you actually got that footage, could you zoom in and get a better picture?
Yes.
And were you able to determine at that time whether the suspect touched the window?
Yes.
What was your determination?
We determined that he was not, or he did not touch it.
Thank you. Nothing else.
All right. Let's go to a break. To defense, I realize that you began talking about your concerns. You have a witness that needs to leave today. 10, 15 minutes. What's your request? I want to maximize your ability to have time with your witnesses as well as cross if you choose to.
Thank you. Just 10 minutes would be fine.
All right, let's break for 10 minutes and then come back and cross-examination. Court is in recess.
10-minute recess. Oh, well, this has just been a roller coaster of a day emotionally. Yeah, a lot of forensic reports here, a lot of DNA mixes, and I bring this up for a couple of reasons. One, it really speaks to the paradox that we're currently in with DNA technology, where it's so good it's become a problem. This is kind of the bottom line. DNA is everywhere. It is in the environment. We are transferring it on the things that we touch. With something like, for example, a box of bullets, a box of cartridges, they're not sterile. You know, they can be touched during the manufacturing process. They can be touched in the store by people, you know, opening up the box. It can be opened up and touched by different people at the range. And under, you know, normal, like household protected kinds of circumstances, DNA is going to persist for a while, you know, if you're not leaving it out in the rain, exposing it to the sun and stuff like that. So part of the problem we have with DNA now is the testing is so sensitive that we can pick up small amounts of transfer DNA, small amounts of background environmental DNA, and that muddies our picture of the significance of what we can find when we find DNA. That gets particularly complicated with these mixtures because mixtures are difficult to deconvolute. And I foresee this being particularly an issue in the case with the rifle and the stuff related to the rifle, because we already know this is a family gun, okay, family heirloom. It's Gramps' rifle. So we would expect there to be possibly family DNA on it. And when you have mixtures with the same family members, it gets even more complicated to figure it out because you expect family members to share quite a bit of the DNA. Not like if it's just some person from the factory, wherever, you know, this particular ammunition is being manufactured, compared to wherever it's being, you know, purchased and used. They're just random people. But with relatives, it's hard because you expect a lot of overlap. So making sense out of it can become a little bit more complicated. We also see the lowest, the like smallest mixture is 3. We heard the other day about, as far as PCAST way back in 2016, criticizing some of these tools for evaluating mixtures. Their cutoff for validating these statistical tools was if the mixture is at least 3 individuals and the minor contributor is less than 20%. So we didn't get the percentage amount. We don't know what the relative contributions are from these different contributors. But this is why the defense, we already know, has highlighted is queuing up challenges to the reliability of this DNA evidence. That's why. It's because of the mixtures. At this point, we really don't know enough. This hasn't been the DNA reliability hearing. And so there's a couple things that will go into that. One, it's been 10 years since the PCAST report. There's been a lot more work done, validation done, technological development since then to potentially overcome that problem they had back in 2016, where they said only 3 people, minor at least 20%. But there was one that was 5, likely to be a bit of a concern. That was the butt plate. That was the butt plate. 5, to my last knowledge, is more than StarMix is validated for. But that's just the last I heard. So we are at some point going to have a big validity of the DNA evidence hearing. We're going to hear a lot of testimony about the technology and the science behind it and how it's developed, the criticisms and so on and so forth. They're going to have to litigate all this. But that's just the highlight of why the defense is focused on the mixture element of this. Tool marks are kind of voodoo, so not surprised Not surprised. Stuff was matched. That will have the weight it has when and if it goes to the jury. This again, Mr. Burt in particular was litigating this all the way back in 2009 when the National Academy of Sciences first criticized tool mark analysis. So we're going to hear challenges to the validity of that too. The one thing I meant to say about the DNA as well is that that's also potentially our avenue into the new cutting edge genetic technology, the next gen sequencing. They can just get a vast amount more genetic information using next gen techniques. So it is certainly possible that the state could pursue additional testing through these other techniques to see if they can better deconvolute these mixes. But they might not, they're not required to. If they do, that's going to be like super crazy interesting to me because of the novelty of these technologies. They're still, very in the very early stages of being vetted for and validated in court. Interesting stuff for me. Saw the photo of the rifle. Guess the New York Post didn't grab it from a stock photo. Guess that didn't happen. Looked pretty much like the one that got published in the New York Post, didn't it? Then the burnt note in the kitchen trash. Gonna have to go through in the recap tonight and go back over what we heard from Lance, because what I thought I remembered him saying is that after he saw it and photographed it under the keyboard, and obviously the photograph that he has is the intact note. He photographed the intact note. And then he said after that, he didn't see it again. And now it is recovered burnt in the trash. Still have a question about who burnt it, but according to Lance's testimony, if he didn't see it again, he didn't burn it. So we would have some evidence of consciousness of guilt there with the burning of that note. That's my recollection, but again, I want to verify that when I get into the recap. The recap stream tonight. So we're well beyond the probable cause threshold. Which I think is kind of to be expected. Just based on what we knew. Saw the comment earlier about kind of overkill, Yeah, they're not going to err on the side of
All right, guys. So I pretty much got the entire show put together for us. We're going to start this in 30 minutes. I'm going to keep the stream going up until we start at 5:30 Eastern time. And I got pretty much everything I need. We're going to be covering mostly everything from the court case today and where that's all going, and some other things that are going on with the DOJ, FBI, and other investigations that are happening. So that's what we're going to get into, guys. A lot of Tyler Robinson stuff to break down here. And I have never seen what I've seen online today from the retard right and the halal right that's coming out of Candace Owens, Ian Carroll, and the rest of these clowns. So it's going to be a great show. We're going to keep this on, fam, and we'll keep this rock and roll, and this will roll right into our live stream, which we'll just keep going. So here we go.
Get through Agent Davis and Sergeant Falmuina, and that was all they had left. So we made good time. The defense has a witness today for us to get through, and then they had one other one tomorrow to get through. But after that, after they're done with their other witness tomorrow, that should be it. So we might get a short day tomorrow. I guess it depends on what it is. If it's the tool mark person and Judge Graff is feeling generous with the defense, we could be there for a while. If we get the same kind of general questioning of the reliability of the methodology as we did with the DNA, For the tool marks, well, there's just a lot more material to work with the tool mark analysis, because unlike the DNA, that one really hasn't developed at all since the criticisms from all the way back to 2009. And those criticisms are pretty significant. So we'll see. That's going to be interesting. Mavka in Sky, I give an adverse interest to the state whenever something is hidden from the public. Thus, they seem to have hidden exonerating material from us. I mean, I don't know. I have to assume. I assume that the parties are largely acting in their own respective interests. And so if the defense wanted us to see it, they would be encouraging that. They would certainly not be fighting it. And, you know, vice versa. So I have to assume there's a reason why we aren't to see these things. Going to stay open-minded about it, but that seems pretty logical. Hang the Conqueror 2025. Quote, I did it, Tyler Robinson, next case. To the extent it's corroborated, I agree. Standing alone, that's what Richard Allen said too. And he didn't. I am very, very confident, comfortable, evidence in the case. Don't think he did. He said he did. But he said he did a lot of things he didn't do because he was psychotic. In and of itself, I did it. Not going to get me personally over the hump, but there's an awful lot of corroboration here. And for all the reasons we've talked about, seems highly likely there is only going to be more as we get into trial and we have more of the digital evidence, we have location data, we have background. You know, they are going to have done so much with his phone. They're going to have done so much with his phone. They will have gotten his basic pattern of life. It's one of the levels of analysis of cell phone behavior. They just look at what does it show about what your day looks like. And what have you done in the past and like what is normal for you, so they can spot something that you do that's out of the ordinary. Does Tyler ordinarily go up to Orem? Has he been there during work hours before? They're going to look for that kind of thing. The targets that they found. They're going to be looking for, when was the last time he went to the range? When was the last time Tyler went to the range? Is there video from there? I mean, there's just so many ways they're going to be able to follow all of this stuff up. And again, all this is available to both parties. And so whoever benefits from that information has the incentive to present it to us. So if it's inculpatory, we're going to hear it from the state. If it's exculpatory, we'll definitely hear it from the defense. So that's kind of where we stand right now, as I see it. Pork Doctor. I like that name. Thanks for your great analysis, Andrea. Shout out to Kelly, Bex, and Sip. We love watching your trial coverage. Thanks. You're amazing. Thank you so much for that nice comment. Love to have you guys here. Oh, this has been an interesting one, hasn't it? I find this all very fascinating. Really just appreciate all of the interest there is in this, and also just in the legal nuance of it. I know there's lots of people watching this hearing, focusing on different things and stuff like that. My interest is the law, and I just love seeing 3,000 of you sitting in here with me right now who have chosen this channel because you're also interested in the law. Mr. Newman, Ms. Newman, everyone look up Erling Haaland, soccer player on Google. Something fun comes up on screen when you do. Unrelated to this case, but entertaining. Andrea, you can just call me Nope. Nope. I will call you Nope.
Noting the presence of all parties, we just ended with a direct examination of the sergeant. Turning to defense, Mr. Burt,
Thank you.
witness.
Good afternoon.
Good afternoon.
your role in the case was kind of as the traffic manager of the whole operation, right?
That's a good way to put it, yeah.
And we're talking about multiple agencies besides the SBI, correct?
Yes.
Your agency, if I'm correct, wrote a massive report, 229 pages long.
Yes.
You've read that. You're familiar with it.
With most of them, yes.
Okay. And it's a compilation, right? You authored some reports, but a lot of other people wrote reports about aspects of the investigation.
Yes.
And as those reports were getting done, you would kind of read them and decide what needed to get done further?
Yes.
Was that one of the roles that you performed in this case?
Yes, as well as consulting with the case agents.
Okay. Now, if my count is correct, 9 of those reports in that larger body of reports was written by you, correct?
Yes.
Did I miss any? Does that sound about right?
Yeah.
Okay. I want to ask you about a couple of those reports. The first report was a report that you wrote on September 22nd that documented the overview of the crime scenes. Correct?
Yes.
And there were various crime scenes that you've described on direct examination, correct?
Yes.
One of them was the Fulton Library.
Yes.
Tell us why that was a potential crime scene.
Yeah, of course. When officers were canvassing the scene, they were also trying to see, right, the route of the shooter as well as just trying to find the shooter. And they determined that the Fulton Library stood out because there were unattended items there at the bus stops that were away from the courtyard area. And so to them, they thought it was suspicious.
And were certain items seized from, and what were they?
Yes, you had a backpack, a jacket, as well as some gloves. And there may have been some other things. I just don't recall them right now.
And do you recall what the item numbers were of those seizures? Was it 9? Does that ring a bell?
I don't remember.
Whatever was seized was sent to the FBI lab for processing?
Yes.
And along with some information that the suspect may have shed some of these items as he fled, correct?
Yes.
Was a decision at some time made, and you were requesting that both DNA and other type of analysis get done?
Yes.
At some point, did you decide to pull a plug on that?
At the time when it was already sent, we didn't have more information as far as whether or not the evidence that were collected there were probative.
But eventually you communicated to the lab that those items were not in fact connected with the case and there was no need to do further testing.
I don't remember communicating that.
Okay. If that's in the notes of the FBI or the ATF, would that be inconsistent with what you know?
No.
Okay. I mention it because some of the reports, the lab reports, have those items listed.
Okay.
I just want to be clear that those items eventually you determined were not related to this case. Would that be fair?
Yeah, that would be fair.
Okay. The second report, at least as far as I can see, that you wrote was on September 24th, and it had to do with looks like a request for a search of firearms. Do you recall that?
Could you elaborate for me on the firearms?
This document documents that NIBIN request for firearms.
Yes, so that was the request to conduct. What that stands for, the NIBIN, is the National Integrated Ballistics Information Network. It is run by the ATF, and that is where we test or we input test fires or cartridge casings, the head stamps and whatnot, into a machine that is then run through the ATF to see if there's any other cartridge casings that match.
And nothing of value came from that part of your investigation, correct?
Correct.
Now, going back for a minute to the crime scenes, you talked about the wooded area, and you used the phrase, "we seized the towel." Who is we? Who are you referring to when you say we seized the towel?
We would be SBI as well as FBI. So that would be myself as well as FBI Evidence Response Team Lead Michelle Kamak, or Special Agent Michelle Kamak.
So you both reached into the bushes and you both grabbed it and pulled it out?
She did, but I was there with her and we were communicating that entire time.
Okay, so when you say we seized the towel, what you really mean is she seized the towel and you observed her seize it?
Yes.
And when she sees a towel, can you describe a little bit more detail of how that process took place?
As far as when it was found or when she removed it?
Yeah, the photographs you showed us, were those the best photos you've got of that process?
That was taken by the FBI, so that's all we got.
That's all we got. And nobody was videoing the discovery and recovery of that evidence?
I believe one of the officers on scene actually had his body camera on.
And have you seen that?
I have not.
Do you know if there's any documentation of the exact process by which that towel got removed from the rifle and then, I guess, put back on the rifle, right?
No, it was not.
It was not put back on?
No.
Didn't one of the photos show the rifle in the box with a towel over it?
Yes. It wasn't over it. It was still wrapped around the gun.
Okay. But as I understood your testimony, the towel was seized by the FBI agent, and then somebody must have reached in and got the gun out, right?
No, I'll clarify for you. So
Sure.
the entire time when we retrieved it, the gun was wrapped in the towel. So when Special Agent Kamak reached in, she grabbed not only the towel, but also the gun. And it remained, and the towel and the gun remained basically intact, lack of a better word, and then was placed onto the cardboard box, which is one of the photos that was shown earlier. Once we documented that, and then the towel was removed from the gun.
You also mentioned as to the other crime scenes that we processed it, but was your role in terms of your actual participation limited to the wooded area? Or were you involved in actually seizing evidence at the other locations, like the roof?
Yep, I was involved in coordinating all that and then determining from there where the evidence would go.
Involved in, is that the same thing as actually being on the roof and seizing the items, or are we talking about something else?
Talking about something else.
And what is that something else?
So after the teams would have packaged all the items, sealed them properly, create an evidence log, they would then bring it back to the command post, and from there we would compile everything, and then there was a discussion that was had as to who would take custody.
Fair to say that you did not observe yourself the seizure of the screwdriver from the roof?
Correct.
And who were the people who were actually conducting that part of the crime scene processing?
That would have been our state crime lab. Those two people are part of our state crime lab's crime scene response team.
When did you review the video of running toward the area from which he jumped off?
That would have been, I don't know the exact time, but it would have been the day on September 10th.
You saw that on September 10th?
Yes.
And when were the windows processed for the latent fingerprints?
The windows were processed on September 11th, the next day.
And was the reason that those latent lifts were taken was because you wanted to rule out whether the suspect had touched that window?
Yes.
That's what the notes say, right?
Yes.
You were not present when that scene was processed either, correct?
Not the entire time, no.
Okay. Now, the other reports that I have that you did, and correct me if I'm wrong, is one report dated September 24th, documenting the forensic analysis as of September 24th, summarizing what you were hearing back from the ATF and the FBI.
Yes.
Okay. And then the fifth report was again about the crime scene progress of the forensic testing, right?
Yes.
All right. And then you have a report here which documents a firearm trace and a firearm seized at River Street.
Yes.
Nothing of value came of that, correct?
Correct.
You have a report that has to do with the latent print report from your people, SBI.
Yes, it's not SBI, it's actually the State Crime Lab, but yes, same department.
Same department. Just detailing the results of that examination, which the stipulation addressed.
Yes.
Okay. You have a report documenting the transfer of evidence from the FBI to your department.
Yes.
And then the last one that I have that you personally wrote has to do with again, summarizing forensic reports.
Yes.
Okay. The larger 229-page report indicates that there was some investigation done by your agency that involved interviewing associates of Mr. Robinson to see if you could develop some profile of him having animosity toward Mr. Kirk, correct?
I'm not familiar with that.
So you weren't involved in that at all?
No.
Some of this documents in that large report indicates that your agency has also, up to the present time, been monitoring Mr. Robinson's mail and communications at the jail. Correct?
Oh, yeah.
Correct.
And have you kept abreast of that investigation?
No.
Do you know whether anything of value has been developed as a result of that?
No.
That's all I have. Thank you.
Well, I'm sure you counseled him to be
Redirect.
cautious about that.
All right. May this witness be excused. All right, Sergeant. Thank you.
Thank you.
Turning to the state.
First thing you tell him.
Your Honor, I just want to confirm with the clerk.
Yeah, let's make sure. Thank you, Mr. Gernander. Appreciate creating a good record.
Judge, if I could just confirm with the court that all of the exhibits we have offered have been admitted into evidence.
All right, so here's what I have, and my court clerk will certainly correct me if I'm wrong. I have State's Exhibit 1, 2, 3, 3.1, 3.2, 4, 5, 5.16, 6.17.
I can't keep track.
7.18, 8.19.
He's too fast even for me in my notes.
10.1, 10.2, 10.3, 11, 12.1, 12.2, 12.3, and I believe 12.4, 13, 14, 15, 16, 16.1, 16.2, 16.3, 16.4, 17 and 18 are blank, so no.
That is correct.
All right.
We're not offering 17 and 18.
All right. 19, 20, 21, 22, 23, 24, 25. The following are blank: 26, 27, 28, 29.
That's accurate. We're not offering on those numbers.
I have 30, 31, 32, 33, 34, and 35, which have been admitted into evidence.
That is all that I have record of.
All right. Does that comport?
Yes. Can we also go?
I mean, we certainly can. Yes. Would you like to put on the record what were published and what were not published?
No, that's okay, Judge.
Okay, we're good. And then, all right.
Can I have just a moment?
Yes.
Those numbers are also not itemized on their exhibit list. So I guess they were going to maybe try to offer them under seal or something. Not real sure.
Your Honor, the state rests its case in chief.
Thank you. Turning to defense. Approach the bench, please.
Can I have us a little sidebar? I guess it's less offensive than when they're obviously arguing in open court and we don't get to see, but the people present do. Oops. Guess I don't really want to mute it. Yeah, curious about these unspecified exhibits. Hi there, sweetie. I got Joni down here. She wants attention from me, but not y'all. Oh, I did the Google search for Mr. Holland. I'm told it's pronounced Holland. That was funny. The little rowing Viking. That was fun. That was cool. That was cool. How you doing, sweetie? I don't have any minnows for her today. Yes. Forensic Fuhrer knows she does want minnows, but I don't have any more. I don't have any more, honey. She has the prettiest eyes of all the cats because she got a little bit of her baby blue.
Get situated. All right, counsel, your request.
Your Honor, as the court knows, the family has asked that all exhibits admitted into evidence be shown here in open court. We are grateful to the court for allowing the family to view many or most of the exhibits today that were admitted. They were viewed here openly in court. And obviously that was done after the court struck what we think is the appropriate balance after a very thoughtful and thorough analysis. I'm going to ask the court to reconsider one of its prior rulings. I understand reconsideration is always a big ask, but I do think, Your Honor, that if the court were to display publicly, or just in the courtroom, Exhibit 12.1, which is the enhanced video, version 12.4, which was played in court, was very hard for the family to view. We think that we asked the court that since the court's considering it, the family should be able to view it as well. When conducting the appropriate balancing, the court, as the court knows, can alleviate any concerns about proper jury selection with certain tools at its disposal. However, if the court were to deny the family the right to view that video, there's no cure. It's either they get to view it or they don't. So we would ask the court to reconsider its prior ruling and to display just in the courtroom Exhibit 12.1, which is the enhanced video. Thank you, Your Honor.
Thank you. Turning to the parties, starting with the state, Mr. Grunander.
Thank you, Judge. The state does not oppose publishing 12.4 in the courtroom. I think we've tried to make it very clear throughout this case that we favor openness and transparency as much as appropriate. I'll submit it on that.
Thank you, Mr. Grunander. To defense, Mr. Burt.
My apologies. That's 12.1, not 12.4.
Thank you.
Judge, at this point in the proceeding, we're asking the court to keep focus on the purpose of this hearing. And as the justices said in the Estes case, the purpose of a trial, and I know this isn't a trial, but the same logic applies, is to determine the defendant's guilt. It's not to educate the public or the victim's family or the world on what evidence the government or the state has. As the court knows, we have witness availability problems. We spent the bulk of today and yesterday arguing about nothing to do with the evidence in the case, but with rights of third parties. And it's appropriate for the court to consider that. But at some point, I think the court has to return to the purpose of these hearings, which is to expeditiously hear the evidence and then determine probable cause. And I want to point out to the court, Ms. Kirk has been very adept at holding press conferences at which she has revealed evidence. She has represented that the state is her attorney. She has access to all the evidence that the state has publicized and that the media and her own lawyer argues is already in the public domain. So they're perfectly free to go outside this courtroom under the court's protective order. They're free to go out and hold press conferences and announce to the world outside the courtroom what they think the evidence is. They have the availability of that evidence. But the court's role, I think, at some point is to exercise some control, move the case forward, and especially when we have witness availability problems. And I'd ask the court, whatever the court does, if you're going to allow revisiting or replaying of evidence for the sole purpose of informing the world or Ms. Kirk or anybody else, that the court do it at the end of the process and not at this point where we will be deprived of our ability to call this witness, because she has to be done today.
Thank you, Mr. Byrd.
Thank you.
Briefly, And I say that because time is of the essence, not because I don't want to hear what you have to say.
I understand, but there was a lot that was just said that's just not true.
Well, so let me put this in a spot where we need to be. And I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth about issues that lie outside of probable cause. And I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family's not seen this video. It hasn't. It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. There's a completely distortion of reality that was just put forth. And this isn't about educating anybody about anything. This is about allowing the family to see the evidence that's been gathered after a 10-month investigation in which a father, a husband was assassinated. That's what this is about. So we ask you to please allow the family to view the video like the court has viewed in order to allow the family to process this moment.
Thank you.
Thank you.
Anything further before the court issues its ruling and we go from there?
Not from the state.
All right. Defense?
No.
All right. All right. So I recognize that the Utah Constitution under Article 1, Section 28 recognizes victims' rights, and the court respects those rights. And as it's been previously stated, balances those rights with the constitutional rights of all parties. I will reserve my ruling on that and maybe revisit it tomorrow. But because we have an issue of expiring time and one witness that needs to leave today, I need to turn to that. I'm not ruling that cannot happen, but for today, we need to focus on this to getting this defense witness on the stand and off the stand. And so please, if I do not remember, the parties can remind me and we can revisit this tomorrow. So again, I'm not saying yes, I'm not saying no. I'm simply saying we need to get to this witness, and I'm happy to readdress this tomorrow. Okay? All right, Mr. Burt. All right, Samantha Carner is being requested. If you can go ahead and retrieve her, bring her into the courtroom. Somebody grabbing her.
I'm guessing
okay,
how that's
spelled. Thank you, Mr. Burt. I just couldn't tell and wanted to make sure.
Guessing it's with a K. Guess we'll find out. Some teeth out from Mr. Bird towards Erica. That could be a miscalculation.
If you wouldn't mind coming forward right by our bailiff to be sworn in.
Need to be very, very careful attacking a victim.
Please raise your hand. Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can sit.
All right, thank you, ma'am. If you wouldn't mind coming forward, having a seat at the witness stand. To your left is a water bottle if you choose. It looks like you brought your own as well. And after you're situated, if you wouldn't mind pulling that microphone toward you, just to ensure that your testimony is picked up on the record. Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Carner.
And Ms. Carner, what do you do for a living?
I am a firearm and tool mark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there?
We'll clarify.
What area of expertise do you have?
I am assigned to the firearm and tool mark unit, so I receive items of evidence related to firearms, tools, tool marks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
Do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens, it's admitted and I think approved.
All right, let's go ahead and put it on all screens because this was
I don't
admitted
disagree with you
and
on this
published
one.
previously.
This has no weight with me, the tool marks.
All right.
You recognize plaintiff's exhibit number 32?
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a tool mark characterization on the cartridge case and the cartridges. And then I also ran a general rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page. Those 2 paragraphs, please. Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes.
Is this the ATS? Is this a language referred to in your report?
It is, yes.
The written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm tool mark discipline pattern examination.
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11.
All right. And what level of publication are you requesting, Mr. Burt?
Both public and admittance into evidence.
To this date?
No objection.
All right. Carner 11 is admitted into evidence and may be published on screens and captured by the camera.
Thank you. And you can publish that. Ms. Carner, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report. And it standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head, no.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says qualifications and limitation of firearm tool mark discipline examination. You're familiar with that part of the policy, correct?
I am, yes.
And the portion of the policy that says a conclusion provided during testimony or in a report is ultimately an examiner's
Everybody look at me. And I'm getting ready to tell you something that's probably going to hurt your feelings, but I love you, okay? The parents are not your friends. I'm going to say it again because I want you to hear me. The parents are not your friends, okay? They cannot be trusted, all right? Amen. Everybody look.
Welcome in, ladies and gentlemen. Welcome to the 6 Hour Show. It's Sky here from Woke Societies. It's episode number 1140. It's July 9th, 2026. Let's welcome in all of our friends over on Rumble, over on Kick, over on X, over on YouTube, and of course, my favorite platform, built by Patriots for Patriots. Let's see all the eyes down the chats over on pilled.net. Welcome in, guys. Welcome into the show. Great to see everyone out there. The trial is still ongoing, but we got the gist of it. There is indeed more probable cause than the judge is ever going to need to move this to a full trial. We're going to break it all down today and discuss what the hell happened in that courtroom, because it was some fireworks for a little bit, and then we got the evidence we've all been waiting for, particularly about the type of round that was used, the bullets. We finally got to see them, the love notes, the text messages, the testimony from Luna or Twigs, and so much more, guys. The breakdowns on X right now, they are the best I've ever seen. So if you guys are ready, smash the red pill. Keep the gold pills flowing, the stickers flying. Please give my mods all kinds of love. We got a show to do. We've been streaming since, I think, 11:45 this morning. Wild. Absolutely wild. We've been really putting the overtime in today. And honestly, the entire week. 02 and on. Thank you for the shades, my friend. Don't tread on me. Roy Stone and Bones. Dougie's still at work. I hear you, my friend. I hear you. We're putting in those real hours here. Ozark Freedom Girl, Wix Vixen, thank you so much. We got Dwana Q of Lurks, Mr. McBastard, Silly Board, Good Old Boy, Dalcon of Truth, Jodalini. We got Lulu, Core Cousin, Down Home Crushing, Tennessee Girls Crushing. Quasam, we got Cyber X Speed out there. Down Home to Scott, like in the dark, me in the skirt. Nasty. Ozark Freedom Girl, welcome in, friends. Welcome in. And a whole bunch of stickers. We got Jack Attack. We got Dong out there. Welcome in, friend. It's May. Welcome in. Willie Fix It. These are Pixels was hanging out here. We got a whole bunch of people that are hanging out here. Mrs. Adventure. This is going back to when the stream was playing originally. Guys, I don't even have the other streams up. Actually, I do. I just don't know where they are. I think YouTube is still going somewhere. Let me just check that. I think YouTube is still going. What up, coffee lady? Oh my goodness. Yeah, Candace Owens, she's going to need a psychiatrist and she's going to need more lawyers. She's going to need more lawyers. What's up, guys? Oh, we got retards in the YouTube chat thinking all the evidence today was fake. Let's just forever remove them from the channel. Yep, those are gone. Oh yeah, do you see guys what I'm still talking about? So here's me. Mark Crank, this is a freaking joke. Charlie Kirk is still alive. Okay, yep. Yeah, so we're just gonna take care of the trash right now. That's gone as well. Yep, goodbye. We're at the point, guys, where you just have to eliminate the cancer. You have to eliminate the psychosis, and just do everything you can to stay away from it. The I don't even know if these people are actual Americans. I would have to assume most of them are foreign bots at this point. And this is the type of stuff that I unfortunately I see this shit every single day. We took a long break from it because it was just not really necessary to talk about concerning Candace Owens and the trial, because I was telling everyone until the trial actually starts, I'm not going to really draw too many crazy conclusions about what's actually going on, because there isn't really anything to go off of. And Candace Owens has certainly proven herself to be a complete fucking fraud, a complete degenerate. She lies about everything. She can't even keep up with her lies at this point. And we're going to jump right into be jumping right into all the trial stuff here in just a minute. But it's great to see everyone out there. Looks like there's some more updates with the with Pilled, so I gotta adjust the Go Pill tab again over here, which is all good. Pilled XP beta is running on everything, which is awesome. And I can't wait for you guys to see the full rollout. It's going to be great. But I just want to give a thanks real quick to all the people that donate to me today. Donnie, thank you for the shades. Heading to work. Want to see this bastard fry. Candy and the Cole are finished. She really, man, Erica Kirk is going to unload on her. Senor Pollo said, I wish more people listen to the actual evidence, not crazy made up theories. Yep, we're going to get into all that today. Cora Cousin with a cookie. Jack Attack with a cookie. Eric Supatria with the shades. Halo Moon, thank you for the shades. Zero Tune On, also thank you for the shades, guys. We were hitting 20K, guys, continually. We're continuing to do it. Thank you all for crushing as per usual. We never miss that goal. You guys always hit it, and today is no different. So, yeah, Cyber, I hope Erica bankrupts her. Yeah, man, that is what I am. That I think is a big reason why the judge wanted to make things a lot more transparent than we originally had thought were going to be out there. And we didn't get to see certain aspects of the audio within the courtroom and some of the legal arguments, which a lot of us were not happy about. But overall, it's been a solid trial. There's been mistakes on both prosecution and definitely defense. The judge hasn't been perfect, but there's no case that is. And we got basically what had happened this morning, guys. Erica Kirk's lawyer basically went up there and said, you know, this is getting ridiculous. We need as much transparency as possible. Like, people understand that that Robinson technically has rights to a fair trial, but at the same time, they've been prolonging this shit for 10 months, and Erica wants the evidence out, and they don't want anything held back because they want the world to see everything that's been going on. So that whole case was made this morning, and even when the media lawyer came up, media lawyer basically was saying to all of America, we don't give a fuck about really Americans seeing what's going on here as long as we can see it in the courtroom. And we're like, hey, what the fuck? Like, we have rights too to watch this. Like, this is a very high profile case. Charlie Kirk was going to be, by all means, a sitting president one day, no doubt in my mind. And that's what he was going for. Everyone that was around him knew he was being groomed to be a United States president. That was his end goal. And they took him out. We deserve to see what the hell is going on here. So that was a big deal. And then the judge basically came in and was like, yeah, we're going to give you guys more video and audio than I originally intended. And that's what he ruled. And big shout out to the fucking judge. Big shout out to the judge, because we weren't going to get that. That was a big mess this morning, but they did get it cleared up. And then we finally get to the portions of what redactions were made, what audio we can listen to. It was kind of a mess. But we finally got to see Luna, aka Twigs. And for anyone asking what the hell is going on, what's with the Luna name? The Luna name with Twigs, which we now know, was in the middle of him doing his transition. I don't know if he's done with his transition. I don't know where he's at with that, because the funny thing is, guys, as you're all gonna see, for as much as these people make about their fucking identity, they make it literally everything. That's all they care about. That's all they talk about. It's all they want to be glorified about. You're going to see Lance finally show up in this video where he's being interrogated by the state. And he looks all buoyed out. He's got his long hair. He looks like a dude. Doesn't look like a chick. Doesn't look like a furry. And I'm like, for fuck's sake, dude. I mean, if you're gonna kill one of ours for your ideology, at least fucking show up and try to look a little bit more tranny for me, for God's sake. I mean, it's your guy's ideology. This is why, you know, one of the reasons that we could probably assume that Robinson killed Charlie in the first place, because, you know, being straight and having families is like garlic to these vampires. But damn, all buoyed up. Just looked like a dude. And I'm like, bro, are you sure you're just not gay? You know what I mean? But Robinson was clearly shaken up when Twig's testimony started being played for the world to see finally. And guys, we covered a lot of cases throughout the years doing the show. It's probably about 10% of the show overall, like of the entirety of doing this for a career. We don't do a lot of court cases. Kyle Rittenhouse was a big one that we covered. This one's a big one. I don't remember if we covered, we did George Floyd. We did all that. Like, we've covered big cases. It's not a big, like, section of what we do here, but when we cover them, they're super important. And today, today was just, it was a wild day. It was a wild fucking day. We're going to get into all the ins and outs of the evidence that was shown. And there's just, at this point, the judge will be ruling, I believe. It'll be ending tomorrow. The hearing's ending tomorrow. I don't know if the ruling will be out tomorrow, but there is no doubt there's more than enough evidence to prosecute and get this to an actual trial. It's crazy that, unfortunately, Erica had to go through this because a lot of states, they just do grand juries. This is all done behind the scenes, and it's a lot more quicker to get to a trial than to have these out in the public preliminary hearings where, they have to relive all this shit. They have to show some of the evidence, not all of it, obviously, and they have to relive this shit. And Erica was seen multiple times getting up and down, crying her eyes out, and it's very humanizing. And unfortunately for her, after all the dehumanizing that Candace has been doing and all the retards in her circle have been doing, it's nice to see Erica Kirk, not in a, not at a TPUSA event, not on a social media, not on X, not in a video, a turning point. This is just her being there, supporting her husband, wanting the facts and the evidence out, just like the rest of the country. And she's there to show support for her now, obviously dead husband. So the preliminary, just the preliminary, it's pretty damning. Yeah, Kimmy, it's bad. It's really bad for Tyler. There's no doubt about it. And I'll give you guys my insights into what I think about Twigs here, because at the end of the day, I think Twigs knew exactly what Tyler was doing. I think it was set up that Tyler created an out or a kind of an act to make it look like Twigs was not involved with this, to make sure his lover did not have to go to prison. And just to clear things up too, Twigs has a limited immunity, okay? There were some people asking if he had full immunity. From what I understand, he was given limited immunity, and I don't know exactly what that means, how far that extends to what kind of I guess grace he's going to be given. I have no idea. He may not be off, some crazy shit can come up. We've seen this in these trials. Crazy shit can pop out of nowhere. You never know. Maybe they both end up going. I have no idea. But as of right now, Twigs, that what we understand, he has been given limited immunity. So we're going to find out. So I hope you guys are ready. We're not doing a news blitz today. We're going to be jumping right into the content. It's been a long-ass day, guys. I've been in the studio for way longer than I ever want to be for a long time. We have one more day tomorrow. And this hearing's over, and I'm hoping I'll have my chainsaw, hopefully by the weekend, if not early next week. I can get my ass back out cutting wood because, damn, I miss it. And it's been way too long. I got more pallets today, but that's I went out, got pallets while the stream was playing, listened to it on my phone, and we're still here. So I'm still doing some stuff, but it is what it is. All right, guys, we're at 2,378 gold pills and counting. Thank you all so much for that love. I appreciate it. Thank you to ZR219 with the shades. And Mez says, if I think that CK is still alive, are you going to boot me? No, Mez, I'm just going to call you absolutely fucking retarded, though. I'm going to call you fucking retarded. And, hey, buddy. Thank you. Appreciate the iced tea. So, guys, shh. Hey, guys, hold on a second, guys. One sec, guys. Hold on. All right, the camera froze in the middle of that. At least the camera froze when my kids came in, somewhat. So that's nice. There we go. There we go. Babysitter got them some Dunkin' Donuts, so I can't wait to get them after the show is over. Hyped up on sugar, so there we go. She looks just like Daddy, doesn't she? She looks too much like me, and I I say to my family all the time, I wish my daughter was ugly. I wish she was ugly because this is gonna be a problem. Those eyes are a killer. She's got my eyes. She's got my eyes, and those eyes are a fucking killer. I'm gonna have to beat these boys with a bat to keep them off of her, but. Thank you guys for being here. I appreciate all the love, guys. You guys rock. And we got a show to do, shall we? So let's get into it. Smash the red pill, keep the gold pills falling, the stickers flying, and please get my mods all kinds of love. We got a show to do, and it's time. So let's get into it, guys. We're going to jump right in the intro. We'll see you on the other side.
Society's fam, you know it's time to go. Grab your popcorn, sit back now, enjoy the show. Severe and non on the mic, so come on, enjoy the flow. The wave is rising and you know it's only gonna grow. Thanks for tuning in to the land of the real. But it's like the Twilight Zone, the plan is surreal. It'll blow your mind when the plan is revealed. Bring it all to light, all the plans they conceal. Grab your flashlight, it's time to go down the rabbit hole. It's dark and hell is hot, dealing with satanic souls. The tide is turning, patriots are now in control. Apply aggressive pressure right now until they fold, stay woke. Open up your eyes and keep them peeled. All they do is lie, realize not everything is real. Through Project Looking Glass, the future is revealed. Future proves past, but there won't be any deals. No time like the present for this music with the messages. The method to my madness, beat the madness to my method. Give you nothing but the truth now to capture your attention. Broke free from the matrix, master the dimensions. People swear they know the truth, but aren't asking any questions. Confirmation bias, so they pass on interventions. For those who know the truth, but they pass it just to mention. Of anything you might say that passes their defenses, wake up and don't you dare go back to sleep. Always keep one eye open for demons on the creep. Once you turn into a wolf, you won't ever be a sheep. A world wide awakeness, now run and tell your peace. Woke Society's fam, you know it's time to go. Grab your popcorn, sit back now, enjoy the show. Severe and non on the mic, so come on, enjoy the flow. The wave is rising and you know it's only gonna grow. Thanks for tuning in to the land of the real. But it's like the Twilight Zone, the plan is surreal. It'll blow your mind when the plan is revealed. Bring it all to light, all the plans they conceal.
I think it's over. I don't want to deal with them anymore, with this scum.
Terrorism ain't what you started. Aliens gotta surrender if you're smart. Jihadists losing their minds onto legs. The retribution for all your crimes. Set it free of the Iranian city where the gold is peace and the girls are pretty. Peace, shut down, yeah, yeah.
All right, welcome in, ladies and gentlemen. Welcome to the show. It's Scott here from Woke Societies. It's episode number 1140. It's July 9th, 2026. Welcome to all of our friends over on Rumble, Kick, X, YouTube, and of course, my favorite fam over on Pilled. Net. Yep, gas is up. Gas is up, but what are we going to do about it? What are we going to do about it? This is why I'm really happy that this trial is going on this week, because, guys, I really don't want to talk about Iran. There's really nothing much to talk about with Iran anymore. They're getting bombed. I think Trump bombed them 90 more times yesterday. 90 more times. And got a bridge in there, too. A bunch of drone sites, more military sites. Actually, mostly, if not all, military sites. And Iran just wants more pain. So that's what our military is going to give them. You know, the gas prices, yeah, I'm sick of it too, but nothing we can do about it. We can scream and cry about it all we want. Nothing we can do about it. And so at least the camera froze on that angle. Dear God. That was a little bit better. That's like me looking at Candace Owens every day when every message that I read of hers. I just want to kill myself. I just want to kill myself. And to get back to the question, because I know my kids came in. Mezzo, are you going to kick me if I think Charlie is still alive? No, I'm not going to kick you. I'm not going to ban you. Like I said, I'm just going to call you majorly retarded. Majorly retarded. And this is why, like, I hate talking about Candace. Everyone that I know in this space hates talking about Candace. They fucking hate it. They'd rather not say her name ever again unless it's pertaining to a lawsuit or that her career's been destroyed. And we are getting there. Trust me, we are getting there. But it has to be talked about. And this, when I see comments like this, hey, Drunk Banana, thanks for dropping the raid in the channel. Thank you so much, my friend. I just want fucking people to come back to reality and just think about what they write and put out in the world. Especially with things like, if I believe Charlie Kirk is still alive. I just want people to really fucking think about the things they say when they put stuff out there. Charlie Kirk has 2 young children, a wife, family, God knows how many friends. Like, and these aren't just, they're talking like Don Jr. best friends, big high-powered people. Like, this man was going to be a president one day. There's no doubt in my mind. And you have to convince yourself that he's still alive. It's just beyond, it's just stupidity. It makes me question your discernment about literally everything. And it's just like, in what world do you think that's a reality? In what fucking world do you think Charlie would put his wife, his kids, his family, his friends through all? Because that would mean most of these people are all in on it. And that's what you have to convince yourself. That UVU, France, Israel, Trump, FBI, DOJ, lawyers, judges, law enforcement, not one of them have fucked up. It's been a perfect cover-up. And yeah, Charlie's still alive. I don't fucking know what happened to people from COVID till up to this point. And I know trust has been destroyed in a lot of institutions, but it's not everywhere. Okay? It's not everywhere. And when I see stuff like that, I try really hard not to get mad, because I used to get really pissed and just lose my shit. And I just don't know where people just think about what you say and think about what's going on in your mind when you're on this subject. Because again, I can't help you. I don't think really any human can help you if you live in this world. The only person that's going to help you from yourself is Jesus at this point. And that's going to be up to you and God to fucking figure out, because it's not going to be me. I have tried so damn hard to help many people, and at this point, I've just thrown my hands up. And today was so big for many reasons, because a lot of it, when we got the initial details, a lot of it was it verifiable, groundbreaking? This is for sure. Some of it was, not all of it. The biggest part for me out of all this was going to be the round. The bullets, the ballistic report, That is what I really wanted to see, because as far as everything else, the motive was there. The person that did this was a perfect cutout for someone who would kill someone like Charlie. The boyfriend, Twigs, the tranny, the engraved fucking bullet casings, which we're all going to see today. It's all out there now. It's all out there. You're going to hear from Lance Twigs. You're going to hear his testimony. You're going to see the actual love letter that was left for Twigs underneath the keyboard that Robinson had told him to go pick up as he was turning himself in. You're all going to see that. You're all going to see that. The only question that I had about this entire case that I was like a little weary about was the 30-06 round. And guys, I'm not a gun expert. I'm not an ammunition expert. I don't have that many guns. I really don't shoot too often. I have them to protect my house and my family. That is all I have guns for. I don't hunt. I don't go shooting. I don't go to target I don't do really any of that. It is in case, God forbid, something happens here, I need to protect myself and my family. That's it. Other than that, I have said, can we please fucking wait to see what kind of round this is? Because there's all different kinds of 30-06 rounds, and all I fucking heard from so many people for 10 months, I'm a hunter. I did this. I've shot fucking moose. I've shot elk that are the size of a fucking bus, and that would have put a fucking giant, a giant hole through a fucking tree.
Uh-oh, retard alert. Retard alert, class.
It's all I heard. And I'm just like, please shut the fuck up. Guys, this is like 10 months of anger coming out right now. Please shut the fuck up. I know. My grandparents have hunted with those rounds. I've shot rifles with those rounds. I've seen what they can do. I've had Full Metal Jacket round. I've shot those. And yeah, 30-06, they can put some massive craters into things. I've seen it. But I've also seen the same fucking guns and the same rounds do weird shit too. And for fucking 10 months, all we heard was it's impossible. It couldn't be. It's all a setup. It's fake. Someone popped out of the fucking ground and took Charlie out. Nonsense. And we finally fucking got the evidence today. So, where I want to begin with this, because I want to catch people up, because there's some people that have been here with me all morning, and there's been a lot of people that have been with me that just started to hop in now. So to kind of give you guys the foundation of where this all started, the prosecution defense, they were all arguing about what was going to be admissible as evidence that's going to be put before the judge to decide if this is going to trial or not. No doubt in my mind, this is absolutely going to trial. I'm not worried about that. What we wanted was the public to be able to see all this, to see what was going to come out of this hearing, what was going to be able to be shown to the public. And the judge ended up overruling the defense, which was great news. And this was that clip. And this is what they were warring over for pretty much the entire day yesterday and some of it this morning.
Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish Exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on Exhibit 16.1, because it contains information, including a phone number and address, to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court.
So I will say this, Judge Graff here he's a good judge. He's a really good judge. He seems like a very kind, decent person on top of it, unlike some of these other judges we have watched throughout the years. And he has done, again, I think his job is to make sure he's got the hardest job right now, because he's got that fine line between looking out for Charlie Kirk and Erica Kirk, and also not breaking laws and making sure that, again, unfortunately, Tyler Robinson has his rights to a fair trial as well. That is not fucking easy. That is not easy at all. Not at all. And he gave us, like I said earlier, he gave us more than what was originally going to be given to us, because the media lawyer was not, they didn't give a shit if we were going to be able to see any video, hear any audio. They just wanted to make sure that the people that were physically there were going to get the goods, because they took the time, they took the effort to actually be there in that courtroom, which is complete bullshit. Because if that's the standard people are setting, that, you know, in today's day and age in 2026, that we have to rely on a few, the media and podcasters, because fucking, you know how that goes, for getting our information in 2026, that's bullshit. We should be able to watch this live and be able to decide for ourselves, have the facts and the evidence laid out, and then we come to our conclusion, and they do their court thing, and they battle that in the courtroom. That's how this should be. And he gave way more leeway for us to do that when no one else was willing to do it. Prosecution, defense, and the media lawyer and Judge Graff here, he gave that to us. So I gotta give this guy a shout out, okay? So yesterday we were supposed to get Lance Twiggs' interview. Didn't happen. The defense wanted certain things redacted. That was a whole 2.5 hour, 3 hour process. They needed to take a night. The prosecution needed to take a night to go through all the timestamps that he redacted, what could go in, what couldn't go in. So they did all that, and here we are. It came back today, and they started playing it. So we're going to start here, guys. If you haven't seen him yet, I mean, this was the screenshot that I threw up for you guys to see. I mean, he looks like a dude with long hair, right? Looks like a regular dude with long hair. But for fuck's sake, man, you couldn't even tranny out. You couldn't even true now for your big day, right? So remember, he has been given limited immunity, okay? And you're gonna get it. You guys are gonna get a taste of what this dude is like. Here we go.
Understand that? Mm-hmm. Okay. First, I'm going to cover some of the things that we've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name, or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do. Yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Looks like a psycho, right?
Okay. And we described.
He's got the nervous gum chewing going on. And then eventually they tell him to put the lotion on the skin. Yeah, side, put the lotion on the skin. They eventually told him to spit the gum out.
Relationship with Tyler when you first met him, anyway.
When I first met him, I didn't know him super well. He was just a new roommate, so I knew he knew my friend group, and I knew he liked playing games, but that's about it when we first, when he first moved in.
He sounds like a troon, right? He sounds like the type, right? Super deep voice, SSRI'd out fucking, and then you always see it in the eyes, right? And we know this guy was fucking hopped up and drugged out like crazy, just based on his everything we knew about him before this trial. He was seeing demons. We've seen his writings. We've seen that his artwork. He's also into the furry shit. Like all these guys, right? It's always the same shit with these people. They're fucking nuts. And they get into this stuff, and I really believe there's a spiritual side to all this, because, guys, I do think they get possessed. I do think they get possessed by demons. I'm not joking. I don't. When you are hopped up on so much SSRI drugs, doing other recreational drugs, you're on these platforms, you're in Discord, you're on Reddit. I feel like your mind can be so malleable and molded into whatever evil entity, whether it's evil entities from the government, whether it's evil entities just regular people online. God knows why you're opening up your soul to when you get into these spaces, you know. And as the interview is going on, this is where the damning evidence starts to pile up. They start getting into the text messages and the love letters, and this is them being interviewed and describing that as that's happening.
Right. You talked about the note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is base number 58. Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
So Tyler Robinson, as he's about to turn himself in, texts his lover, Lance here, says, hey, I left you a note underneath my keyboard. So Lance goes under the keyboard, he reads it, realizes what Robinson has done. He then takes a picture of the letter. So Twiggs has an actual photo of the letter that he left for him.
So where did you find this?
On his desk underneath his computer keyboard.
And I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
Right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
And you guys are wondering why the screen is black, right? This is why I asked you guys yesterday, who do you hate more, politicians or lawyers? 3 fucking hours of arguing. The defense was arguing that they did not want to show Lance's facial movements, his body language. They didn't want to have that out there because they believed it was going to hurt their client's case. And the state was basically like, listen, we need to show this because this establishes our foundation for our case to prove that he is actually guilty in all this, to get this to a trial. And the judge ended up ruling that certain aspects of the video were not going to be shown, but the audio was going to be allowed to be shown. It's retarded. It's gay. This is the thanks to the lawyer Novak that talks like a fucking tortoise, as slow as a tortoise. And this is what they do. They delay. This forced the prosecution to then have to take an entire night to go through this and black out certain aspects according to what the judge requested after they made their objection. And they were left. This is what they were left to do last night. So that's why you're seeing a black screen. Some parts they were able to show Robinson here or Twiggs here. But the part that you guys need to get is that Tyler Robinson sent a text to Twiggs and confirmed he did indeed find a note on Robinson's desk that admitted that he left to go, quote, take out Charlie Kirk. If you were reading this per my text, then I am so sorry. I left the house this morning on a mission and set an auto text. I am likely dead or facing a lengthy prison sentence. I had the opportunity to take out Charlie Kirk and I took it. I don't know if I will / have succeeded, but I had hoped to make it home to you. I wish we could have lived in a world where this did not feel necessary. I wish I could have stayed for you and lived our lives together. Now, this was already out there when this was already out in the public, this part here that we just read. Why this is significant now is because we now have Twiggs on video confirming this actually happened. This isn't just hearsay anymore. And this is a part where Tyler Robinson is talking about, or Lance is talking about Tyler here, saying that Robinson was acting very erratic after killing Charlie. And then he explains that he wishes he hadn't done it.
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home.
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. He started crying a little bit and said he wishes he hadn't done it, and then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
So there they go. They have to redact it.
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
So interesting admission here. Twig said Robinson told him that he, quote, wishes he hadn't done it. I just asked him in person if what he said was true the night before, and he said it was. He started crying a little bit and said he wishes he hadn't done it. And then eventually Robinson said that he would talk to his parents or turn himself over. I mean, that's pretty fucking damning, I would say, right, guys? I would say that's pretty bad. You know what's interesting to me about this is that, you know, do I think Robinson is proud of himself that he killed Charlie? I still think so. Do you want to know the part that I think he regrets? I think he regrets falling for the propaganda. That they truly believe Charlie Kirk was some fucking like Nazi right-wing extremist. And realizing that he killed him. And yeah, it's going to change some things. It's going to obviously affect a lot of people's lives. But as far as like what he probably thought or fantasized in his head as the outcome didn't happen. Yeah, we had the demons and ghouls celebrate when he was killed. We saw people out in these protests, these lefty protests that celebrate Charlie's death and depict him, and people even out was in California, right? Where you had people at these you had these lefty protests in front of ICE facilities dressed up as fake Charlie, fake Charlie masks with blood on their necks, right? Yeah, the demons are out there. But I can guarantee you it didn't have the effect that maybe that Robinson thought it would. The hero that he may have been portrayed, because there is none of that happening here. I don't even see the left. Do you guys even see the left? The left are celebrating that Charlie is killed, but you don't see the left really celebrating Robinson. Isn't that weird? And guys, I mean, I follow this stuff closely just as much as anyone else, and I see these leftist accounts. I watch them all the time. You don't see them like proffering up Robinson like you see someone like Luigi Mangione. It's the weirdest fucking thing. And my theory in all that is that these two fags essentially that fucked each other, and they are the worst aspects that culture knows and normal people are disgusted by. And they don't want that shit out in the open maybe as much as they thought they did. And I think that's why they don't like, Robinson is just not that hero to them. Mangione seems to be one of them to them, but not Robinson. And so Robinson said he said he wished he hadn't done it. Now that could just mean maybe he wanted to die. Maybe he thought he was going to be in a shootout and get killed. Maybe he just realized his entire life is ruined no matter how this goes down. But he had some regret. Allegedly. I don't know, because this motherfucker's been seen many times laughing in court. Just as recently as yesterday. Not laughing today, though. Not laughing today. But you have an admission here saying he wished he didn't do it. And this is what Robinson's defense was desperately trying to hide for hours yesterday, throwing monkey wrenches in with the objections. And these are the text messages that came out today also in court. This is them. Try to get these up here as clear as possible. So it says, I love you. Love you too. Hope work's going well. I love you. I love you, Morsies. Moi, moi, moi. Okay, dude. Drop what you're doing. And so this is Robinson saying, drop what you're doing. Look under my keyboard. What? You're joking, right? Robinson said, fuck, I tried to delete that. I'm going to give you guys my theories on why I think these text messages are going out. So I'm still okay, my love, but I'm stuck in OREM for a little while longer yet. Shouldn't be long until I can come home, but I got to grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. You weren't the one who did it, right? That's Twigs to Robinson. And he writes, I am. I'm sorry. Remember when, do you guys remember when Candace Owens was screaming to the world that, oh, look at those text messages. Look at the screen caps. They look modified. This is Fed slop.
Uh-oh, retard alert. Retard alert.
Fed slop, that she called it. No, it's all fake. None of it's real. Okay, so let's take pictures of the actual phone with the text. This is Lance's phone, and then put that out for the world to see. And at the header for the contact, you can see it says Tyler with hearts on it. It says, he admits, I am. I'm sorry. I thought they caught the person. Said, no, they grabbed some crazy old dude, then interrogated someone in similar clothing. I planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering. So he's actively trying to get the rifle. Says, I don't want to chance it while they are parked there. If they had found it, I imagine there would be more commotion. Again, I'm so sorry for roping you into all this. You shouldn't have to worry about this. Does anyone else know, Lance says? Not to my knowledge. It's going to be real fucking annoying till I can't get this thing till like 3. Then I have to drive and still get into it. So this guy was full out planning to go into work the next morning. You're sure they aren't waiting to see if anyone comes to collect the gun? And said, I've gotten close enough that they would have jumped me if they were waiting. Says, just stay safe. I will. I'm more worried about what my old man would do if I didn't bring back my grandpa's rifle. He's far scarier than any Fed, not gonna lie. Guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off. So, interesting little note here that he says he is more afraid of his father than a federal agent. And that tracks because who turned him in? Who turned him in? It was his own family. And guess what, guys? We haven't even gotten to the family's written statements, video footage. We haven't gotten to any of that yet. I'm sure that's being saved for the actual trial. This is why I'm saying, guys, this was a sealed deal from the get-go. Tyler's parents made him go in. They are not going to lie for him. And anyone that's actually been watching the case, you haven't seen Tyler once turn around to look at his family. Not fucking once. Not once. Tyler's mom was seen crying a few times. Erica has been a mess, which is to be expected. But all these text messages went out for the world to see. Incredible, right? That is admittance of guilt. You cannot get around that. And what was interesting is the last 3 days, Tyler seemed pretty chill. He was in a good mood. He was yupping it up with his lawyers. He was smiling, laughing a little bit. It's fucking disgusting, right? It's disgusting. Today, not so much. Not so much, because apparently when he sees Lance, he gets all up in his feels.
Our digital reporter, when they got to the point discussing the rifle that was used, Tyler Robinson was squirming, apparently uncomfortable, swinging in his chair, scratching his nose. He looked uncomfortable with the texts that were being discussed. Also, Erica Kirk was looking down, leaning forward, not looking at the screen showing those texts. Our reporter also said Erica was audibly crying throughout the proceeding today. When they got to the part about Lance when he was asking Tyler Tyler about the rifle and for hunting, the very graphic detail about the nature of the gun that Robinson said did well in the killing. That is when Tyler Robinson's mom started crying and wiping her eyes. Charlie Kirk's mother had her hand on Erica's upper arm and shoulder, and they were both tearful today. After showing the Discord chat logs, the prosecution also put the note from Tyler Robinson on the screen. That's the handwritten note that's been discussed that Tyler Robinson left for his lover. Our reporter inside of the courtroom says it was a very lengthy, full-page handwritten note. Trace.
Yeah, Matt Fenn, back to you as the news warrants. Thank you. Meantime, at the courthouse, we've also got Donna Rotuno, criminal defense attorney, host of the Crime and...
So, squirming, uncomfortable, swinging in his chair. I guess when they fucked each other in the ass, you know, they get the feels and they see each other on screen, apparently. I don't know about now. I wonder what he thinks about Lance now. And another interesting part that came out of this video, Lance was asked about was there ever any talks about LGBTQ rights leading up to Charlie's assassination?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in like their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did you ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay.
Do you all believe that? I don't fucking believe that one bit.
How about political issues?
Yes, Jolene, Charlie's parents were there.
So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current like policies being like issued or voted on, I think. But yeah.
So he claims that he never talked about Charlie Kirk, only talked about Trump in generic terms and just policies that were being voted on or being enacted. I can tell you guys right now, I don't believe that for a fucking second. I really don't. I personally believe, because this is the thing, like, Tyler did everything he could to make sure to wipe the fingerprints off the rifle. That's what he was trying to do with the towel. Didn't work out. He ended up leaving it there. Obviously, authorities found it. They have his DNA. They have Twig's DNA all over the towel. They have Tyler's DNA over the towel. And it's like he had a drop point. He was scouting the area. Like, this was obviously all premeditated, right? And you're going to tell me that Twigs had no idea this was going down? There was a portion of they played 23 minutes. The entire video was 23 minutes, and that wasn't the full video. It's what the judge allowed the public to see. They get into the bullets, where Tyler asks Twigs, "Hey, can I have a Dremel?" And he's like, "Yeah, what do you need a Dremel for?" He's like, "Well, I want to engrave the bullet casings on these bullets." He's like, "Okay," and he had asked him, "Well, okay, what are you doing?" And Robinson said, "Oh, this is going to be for a family hunting trip." And I'm sorry, guys. Like, I don't care who you are in a relationship with, whatever it is. Like, if you're with a significant other and they're engraving shit into bullets, I mean, you're gonna ask why. You're gonna wonder why. Like, isn't that just common sense, fam? Wouldn't that just be common sense? Like, why are you engraving bullets? It must be something really special, right? Like something memorable. Like, and you'd probably okay, that's fine. Like, can I see it when you're done? Like, that's what I would ask. And he plays it off like it's nothing. So people are saying, like, why would Tyler send all these text messages to Lance? Like, it's completely damning to him. And I said it before. I think this is to protect Lance and to put it all on Robinson and do everything he can to keep Lance out of all this. Protecting his lover. That's what I think is happening here. And I think also, again, this is just my theory. I could be completely wrong on this. I think this is why Lance got limited immunity. Not full-blown immunity, limited immunity. Because there's a lot more out there that we still don't know. So, and this part here is where, again, this is the damning shit. You have Lance identifying Tyler here and saying he thinks that's him in all the security videos.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images. Okay, I'm on the FBI's website. You can see the URL there at the top. This is some press release about this event. And here on the screen, you see these, looks like there's 2 rows of 3 images.
Mm-hmm.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat.
Oh boy.
And then jeans. So it definitely, especially the bottom, the last 2, definitely do look like him.
Oh boy.
Oh, they do look like Tyler Robinson.
The last 2 definitely look like Tyler Robinson.
And you talked about that with your friends, right? This looks like him.
Yeah, his friends. Yeah, I don't know if I talked. I don't remember if I talked about it with any of my friends. And then since I didn't have my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
So he identifies his glasses, his shoes, says the last 2 really do look like him, names him from the video. I mean, it should tie it up, right? It should tie it up. And then this was the big moment that we've kind of been waiting for. For me, this is what I've been waiting for. This was the introduction of the evidence of the rounds, okay? So you guys saw the really important parts from Lance's testimony that we were allowed to see today. About half that video was cut out because of the defense, because they're hiding shit. They know it's damning, and what was already put out today was damning. And the other thing I want people to think about, too, is that for anyone that thinks this is all fake, this is all made up, everyone's in on this, you do have to realize there's high-powered lawyers like Novak on the defense team right now, that if there was something nefarious going on or fake going on, or if the text messages were fake, you don't think the defense would have introduced evidence to show that, to prove that all this is nonsense and fake and save Tyler from even going to a trial? Career lawyers, well-known names throughout the country that you're going to convince yourself and others around you that they're all in it on this too, all in on the conspiracy that had nothing to do with them originally, and they're all in on it too. Judge Graff, Novak, the state, like all this is just hundreds and hundreds of people. They're all in on this. Bro, people need, they need to get help. They need to get help. Royally need to get help. Because at any point, and this is the thing, guys, this is why I personally am watching the trial and then giving you guys my takes and all this. At any point, again, like all this stuff with Lance was out there. Guess what? Did the defense put up any objections or want to cross-examine any of the witnesses today that were laying out when they met Lance, what was said to them? 0 objections. And the judge gave the defense opportunity for cross-examination. And guess what? They didn't take it. Especially when Lance's interview was done. Because they know it's fucking bad. Like they're already in a really dark hole already, a deep hole already, right? So they're not looking to dig a hole. Because if they dig a hole, it opens them up for the state to come back and then re-hit them again. So they're taking the damage. Like, all right, just let it. We got to take this, and that's it. We're good. No judge, no cross-examination. We're good. Because first day or two, the defense had opportunity to cross-examine the investigators. They wanted none of that today. None of that today. And this is why I'm saying, fam, common sense and reality is a fucking thing still. Not everything is conspiracy theory. Not everything is a lie. Don't OD on the red pill. All right? It will send you fucking crazy. This is clear, cut, and dry, in my opinion. So the bullet, finally. We finally get to see the bullets. We've only been seeing them in text. Utah Police Sergeant Jennifer Fiamuna reads through the engraved 30-06 rounds recovered with the Mauser 98 rifle recovered near UVU. As reported earlier, the engravings include, "Hey fascist, catch, notices bulge, OWO, what's this? And if you read this, you are gay, LMAO." Sergeant Fomiana also describes identical 30-06 rounds being recovered from Tyler Robinson's apartment. One of the recovered rounds is a spent shell casing with the engraving, quote, "test shot." So let's get into this, shall we? This is what we were waiting for. Let's look at the actual round the first time.
Let us start with Exhibit 19, please. What are we looking at here in Exhibit 19?
This is the cartridge case that was recovered from the gun.
And what position was this in the gun?
This was the...
So you're looking at, guys, so this is the bullet. This is the casing that the bullet was in that killed Charlie. And the one that got him was notices the bulge. This is tranny talk for, obvious. When you have a bulge, it's your dick and balls, but you're a tranny, right? You want to be a woman. So this is like Reddit lefty trans lingo here on these bullets. And this is the one that killed Charlie. Horrible. This is the casing.
Or this is what was in the chamber.
Okay. In the chamber, meaning that's where a cartridge is before or when it is fired, correct?
Yes.
Do you notice an inscription or an etching on this cartridge case?
Yes, I do.
Will you read what that says?
Yes. Notices bulge.
And if we can go down to page 2 of the exhibit, will you read what this says?
OWO, what's?
And to page 3?
This.
And question mark, correct?
Yes, question mark.
All right, if we go to State's Exhibit 20. Is this a photograph of one of the cartridges that was found in the gun?
Yes, it is.
And what are we looking at here in this view of page 1 on Exhibit 20?
This is the head stamp of it, and it says it is according to the head stamp, it is a Remington 30-06 Springfield.
Is that a different caliber?
So it's confirmed. It is a 30-06.
Than a .223 round?
Yes, it is.
Will you look at page 2 of Exhibit 20? Will you read the markings here?
A fascist.
A fascist. And guys, notice the tip of the bullet. Is it pointed or is it rounded? This is the bullet. Hey, fascist.
And page 3.
Catch.
And page 4.
Up arrow, right arrow, down arrow, down arrow, down arrow.
That's like, I know this from Gaming World. That's like a cheat code.
All right, let's go to Exhibit 21. And was this another round that was found in the gun?
Yes.
Will you read the inscription here?
Oh, Bella Chow.
Page 2.
Chow chow.
All right, let's go to Exhibit 22. Another round that was found from the gun, correct?
Yes.
Will you please read the letters here?
If you read
Page 2.
this, comma, your, or correction, this, comma, you are
Page 3.
gay.
And page 4.
LMAO.
The fuck, man? What the fuck? Deranged. If you read this, you are gay. LMAO. Again, like, what fucked up mindset do you have to be in to write these things? A fascist catch, Bella Ciao, anti-fascist song lyrics, right? If you read this, you are gay. I mean, this was all the shit that was etched and carved into the bullets. Like, we had not seen these until today. They were all in text. They were all in reports, but we had never seen them. And what I wanted you guys to see, the bullets, they are not tipped. They are rounded. And this is what I was waiting to find out, because there's so many different kinds of rounds, different 30-06 rounds. Some are made to penetrate. Some are more flangeable. They mushroom, they shatter, break into pieces. And what we know now is that these bullets were soft point, or what's called expanded jacketed rounds. And remember, guys, again, I heard from so many people, I've shot moose. I've shot fucking, name big animal, the fucking Nessie, the Loch Ness Sea fucking, you name the fucking creature. Hunters have shot it, and they put massive crater-sized holes in these animals, alien, what the fuck they've killed, right? Guys, we heard it for months. And I'm like, you cannot tell me, I don't give a shit about what experience you had, how many, what hunter you are. I don't care, because guess what? We don't know what type of round this was. And I told everyone to chill out and to calm down, and let's figure out what the round is first, then make a determination. And oh, what did we find out? We find out it's called an expanding jacketed round. And these rounds are designed to basically break and shatter, which will leave a lower probability of it actually going through Charlie. And guess what? We know they found shattered rounds, or a shattered round, inside Charlie's body. That's on the ATF report that came out months ago. So everything that we're being given here and everything we're being shown by the state is lining up with what's happening, or what has happened. And the Misfit Patriot, he's okay sometimes. He hates, the thing is, I can't stand him, but he hates Candace as much as I do. And he was on this as well.
Okay, guys, we finally have actual new information that confirms the type of bullet that was used to kill Charlie Kirk, the one that was found in Tyler Robinson's rifle. Remember, that had his DNA on it. The rounds had his DNA on it, and the bullet that was found in Charlie Kirk's neck was an expanding or potentially frangible round. Now, these are the ones that he was engraving. I want you to look right here where my finger is. That is, without question, a soft point round, or an expanding jacketed round, right? Not the exact same thing as a frangible round, but behaves very similarly a lot of the time. So these are designed to expand on impact, open up, and when they hit things like bone, they break apart. Right? This basically is not necessarily new information, but it's confirmation of information that we already have. And this is stuff that a lot of people online, they see a video of one of these that's going into like some ballistics gel, and they're like, see? Right? That's not a true accurate representation of the human body, because there's no vertebrae in there. There's no muscle tissue, blood, what have you. So what this will do to a piece of ballistic shell is make it look like it explodes as opposed to a human body. There's also people that are shooting frickin' like cast iron plates with full metal jacket rounds. It's just not a one-to-one comparison, right? So again, right, soft point bullet, expanding jacket round lines up with what we're seeing with the medical examiner's report, with the actual video, right? Where very heavy kinetic energy that you can see in the video, right? That's what an expanding round would do. A full metal jacket might have just zipped right through, and this did not. So again, not new information, confirmation of what we already knew or what we already assumed, which was that this was a soft point bullet or a frangible round. It is a soft point bullet. Sorry, Candace, you're a fucking retard. I'm going to end every video like that, I think.
Yeah. Yeah. This for me, guys, again, this has nothing to do. Again, this is all about Charlie and his family and his friends getting the redemption they deserve. Me personally, guys, this is why I have been willing. I am willing to go out on a limb and lose what little following I have left in some regards on social media. I'm not talking about here live streaming, just social media. I haven't been able to I've been stuck at 125.9 on X for months now because I get a lot of people that share my shit. It goes crazy, and then the moment I shit on Candace or Ian Carroll or anyone in those circles, my followers just drop, and I don't give a shit. And you guys have been watching me for a long time. This is just confirmation that, again, I'm not trying to steer you wrong. I'm not gonna bullshit you. I literally said, can we just wait to see the ballistics and the bullet, and then we can just determine we can determine from there? Is that wild, guys? Is that fucking crazy? What a concept. What a concept. And guys, I don't know how many videos that were sent to me about they're calling the ballistic bros, right? The ballistic bros, the YouTubers, guys shooting fucking cast iron fucking pans. Pigs, you name it. I got sent the videos like, Scott, I just don't believe it. I just don't believe it. I'm like, stop sending me the fucking shooting videos. I don't care. Stop sending them to me. Just wait. We got it today. And what's the conclusion? The conclusion is, yeah, we kind of figure, the rational people figure, but at the end of the day, it's Candace, you're retarded. That's the conclusion. That's the biggest conclusion that we can come to. Candace, you're fucking retarded. The other things that came out today, fam, were a burned handwritten note. She described a burned note with visible handwriting on it that was found during a search of Tyler Robbins' residence. This appears to be a remnant of Exhibit 16-3. Good thing Twigs took a picture of it, so we all got it. The handwritten note left by Tyler Robbins for Lance Twiggs, which Twiggs photographed prior to it being destroyed. So that's basically him admitting it on that paper, but we have a picture of it, so that didn't work out. And then we finally got the photos of when law enforcement found the rifle in the tree line. And it wasn't really hidden too well. It was not out, it was pretty out there. And there's a towel, probably with cum from both these douchebags. Disgusting. And then there's the rifle. There's the actual rifle. So we know what it looks like now. We can confirm everything that we've been told up to this point. This is all out there for the world to see now. And again, this is what I can show you guys. Again, this was not supposed to be shown in the court, but the camera guy fucked up. We got a screenshot of it anyways, but basically this was the thing that was burned. If you're reading this per my text, and I am so sorry, I left the house this morning on a mission and sent out an auto text. We read this already. I had the opportunity to take out Charlie Kirk, and I took it. It's just, did you see why the defense didn't want any of this out? It's super damning, right? And then let's just throw on the cherry on the top, on top of all this for you guys. DNA testing linking Robinson to the 30-06 rifle. Swabs of stock and bolt of rifle, the DNA profiles are at least 1 trillion times more likely if they originate from Tyler Robinson. 1 trillion times. Swabs of the butt plate, 1 trillion times likely from Robinson. Swabs of trigger and trigger guard, 1 trillion times more likely to originate from Tyler Robinson. Swabs of fore end of the rifle and 30-06 cartridge, 1 trillion. Swabs of the barrel and another 30-06 cartridge, 1 trillion. Swab of the optical accessory, the scope, 6.28 billion times more likely it originated from Tyler Robinson. I don't know, guys. You tell me. Is all this just bullshit, or is is this the real evidence, or is what Candy's putting out there for the world to see? It's all made up. Not the DNA evidence, the rifle, the casings. It's the ideology, the love letters, the text messages, the confessions on camera. And guess what, guys? Guess what? They're not going to bring the parents in yet. You know what they're saving the parents for? The family friend. That's going to be saved for the trial. And guess what? That's going to, you're not going to overcome that. Unless something comes completely out of left field that no one's seeing. This guy's cooked. Fucking cooked. 1 trillion times more likely, guys. Not IDF, not the Jews, not the French Legion, not any of it. Not fucking any of it. And remember, people forget that Tyler's parents, they brought him in. They told him that they turned themselves in. They immediately knew from the video that it was their son. They knew immediately. The timelines of when he was at the campus are established. And his own family and a family friend brought him into the sheriff's office. It's just what else is there to say to the people that have been trashing this from the get-go? And I think at this point, guys, when you're watching the defense, all the objections were really the most objections they put out were to try to prevent this from even coming out at all. Once they lost that, you notice the objections almost completely stopped. And the judge just kept steamrolling. Nope. Admissible. In the evidence. Just kept steamrolling the exhibits. And the judge is like, okay, do you guys want to cross-examine the detectives, the officers that have come in today? And the defense is like, nope, we're good. We're good. So what I'm wondering is, because the thing is, there has been no plea from Robinson yet, because there hasn't been technically a trial yet. What I'm wondering is, because this judge, I don't know if he's going to rule tomorrow, but the preliminary hearing ends tomorrow. The judge is going to rule that this is going to go to court or go to a trial. And I'm wondering, guys, if they're just going to go for a plea deal. And I'm wondering that because they could just go for a plea deal and he's going to be in life. He's going to be in prison for life. We want the death penalty because he fucking deserves it. Will they take a plea deal, or will they risk this going to trial? Because at the end of the day, what else do you have to lose, right? If you're Tyler Robinson, you probably want to go to trial on this, because you might get a bunch of Candyland jurors that might get him free on a long shot. Maybe. Who knows? It's going to be really interesting to see what ends up getting decided here. Very interesting. Now, on the onslaught of all this, and guys, let's move everyone to pill.net right now. I forgot yesterday. I don't want to forget again today. Off of Rumble Kick X YouTube. I don't have the chats open for you guys. We've been streaming on the same stream for a while. So let's just move everybody over to pill.net, because I want to get into the analysis of what's happened on X and the other platforms that I've been watching. I have never seen so many people turning on Candace since this whole thing started. And it's getting bad. It's getting really bad. And not just Candace, but for all the people that I blocked, because they're all the same. Owen Schroyer, Clint Russell from Liberty, all the libertarians. Libertarians are in the same camp as the left, in my opinion, at this point. I can't fucking stand them. They don't stand for anything. They're retarded and completely irrelevant. So let's move everybody over to Kick, or everybody over to Pilled. Over Kick Rumble X YouTube. Thank you guys for joining. We got one more day of double duty tomorrow, guys. And next week we'll be back to regular shows. Full 2 hours, all that good stuff. We've been streaming a shit ton. I don't have a chainsaw, so I haven't been able to do my side biz. So we've been doing this instead. So let's move over to Pilled. We'll see you guys over in Pilled. Goodbye, my friends. All right.